B. Borgohain, Lordship.
Borgohain, the learned counsel, appearing on behalf of Mr. S.G. Borua.
Mr. S.G. Borgohain.
S.G. Borua, the MS S.G. Borua, the learned counsel, appearing for the petitioner. Praise for adjournment of the matter. Prayer is allowed. Let the matter be listed after 3 weeks.
After 3 weeks. Master plan.
Lordship, I beg to mention item number 18. Lordship, this is a 2019 land compensation matter, but on the last 4 to 5 occasions, this matter did not even reach because it was always listed at the bottom of the list. This matter did not reach due to paucity of time. As well as my humble prayer is that can this matter be taken up at 2?
No, it will go according to the list.
Obliged.
Yes.
My lord. My lord, on the last occasion had posed three
Yes.
queries, my lord.
Yes.
Cooperation. The first query was whether any other bidders' bids were rejected on similar grounds, my lord.
Yes.
I reached out to the IOCL. No, my lord. The petitioners were the only two bidders, my lord, whose bids were rejected on the ground of non-conformity with the procurement of the registration license, my lord. The second ground that the lordship had query that lordship had posed is whether an LOA is a final document or it is a contingent document, an argument that I developed, my lord, during the argument, my lord. In that regard, my lord, I have 3 judgments that I like to put for before his honorable court.
Okay.
First, my lord. Maharishi Dayanand University and another 2007 5 SCC 295, my lord.
Yes.
The facts are slightly different, my lord, but I'd like to iterate the principle which has been laid down by the honorable court, my lord.
Which para you are referring
My
to?
lord, paragraph number 4 and paragraph number 12, my lord. Paragraph number 4, my lord, with regard to the facts of that case, it is stated that the tender so submitted by the respondent was accepted by the appellant. It was stated in the letter of acceptance dated 22/1/11/2003, signed on behalf of the appellant, as approved by the tender committee in its meeting held on so and so, and further approved by the competent authorities. The acceptance of your tender for the work cited as subject is further conveyed to you on behalf of the registrar NDU Rohtak at the rates contained in your tender dated 12/9/2003. Then, my lord, this is subject to the terms and conditions of the approved detailed notice inviting tender of the above works, my lord, which is similar to the clause in the LOA in the current writ petitions, my lord. Then, my lord, we'll kindly come to paragraph number 12 at page 303. The second last page, my lord.
Yes.
The present case is governed by the procedure that was available when Konkan Railway Corporation Limited held the field. That orders already made were not to be affected by the ratio of the decision in SBP and Co. is clear from para 46 of that decision wherein prior orders and proceedings have been saved. Therefore, the only question for decision is whether the fact that the parties have not signed the contract containing the detailed specification as contemplated by the letter of acceptance would preclude the respondent from seeking an arbitration by falling back on clause 25A of the tender conditions quoted above. It is true that when parties during negotiations contemplate the execution of a formal agreement incorporating terms of the bargain, so long as a formal agreement has not been entered into, my lord, it may be open to contend that there was no concluded contract between the parties. As against this, what is the position in a case where the tender submitted is accepted, its acceptance conveyed, and the time for completing the work is stipulated to start from such acceptance, and the work was to commence on the basis of that acceptance, but no payment was to be made until a formal contract was signed? It is the first question that arises in this case. We think that in the circumstances, this is a question that must be left to be decided by the arbitrator. My lord, this pertains to the arbitration clause, my lord. In this petitions, my lord, my humble submission is that no formal agreement or work orders were signed pursuant to the LOA. And
No, that is not disputed.
my lord, that is not disputed. My lord. The
Mm.
other judgment, my lord, State of Madhya Pradesh versus firm Govardhan Das Kailash Nath, my lord.
So what is the ratio here?
The ratio is, my lord, as I understand at paragraph number 12, is
Hmm.
that unless, my lord, it is true that when parties during negotiations contemplate the
Correct, correct. So that question is left open
My
to the arbitrator to be to adjudicate
My
and
lord.
decide.
Yes, my lord. In this
Correct.
case, my lord, the
Mm.
LOA
Mm.
was subject to
Mm.
furnishing of certain other documents pursuant to the tender, which has been mentioned in paragraph number 4 of this judgment, which was not admittedly done by the petitioner, my lord.
Mm.
Right or wrong, they could not do it
Mm.
before the date of issuance of the LOA. So the LOA, contingent upon the conditions laid down in the tender, would not proceed further for a formal agreement, and no right has accrued in favor of the petitioners because they failed to fulfill.
But
the terms of
they
the-
have now but see, I mean, this formal agreement was not signed. Correct. That is not a disputed question.
True, my lord.
Now thing is that now they have whatever the terms and conditions that has been laid down in the NIT.
My lord.
Now they are fulfilling it by the way of like now obtaining that registration certificate. Now that term that point has been complied with.
No,
But what is the timeline? Timeline you have not given.
My lord, the two aspects, my lord, reading paragraph page 51 and 56 together. 51 tells.
No, correct. So
as I
see,
understand-
let us take it like this.
My lord.
See, LOA has been given. LOA has been given with due scrutiny, right? Due scrutiny was done and LOA was given.
Was issued, my lord.
So, but there are certain things that has to be complied with as per the NIT. Now, one of the things maybe that is that registration certificate that they have not given earlier. Now they have it with them. They want to give it now. But because formal agreement is not signed as yet.
My lord.
So what stops you from taking that?
My lord, the prejudice that would be caused to other third parties who are not before this honorable court, who did not partake in the tender because they did not have the qualifications which are laid down on the page 51. Now, my humble submission is that, my lord, a tender is not an open-ended document. A tender has to have a start date and has to have a date for compliance of all the necessary criteria.
Correct.
Now, in this regard, my lord, when your lordship has rightly pointed out that page 56 does not lay down a timeline, and you can say that if you have applied, you can furnish that as a proof of your application. Now, my lord, I ask myself a question. The tender closed on 12/5/2025. Thereafter, the LOA was issued on 16/9/2025. Now, until that point in time, my lord, the petitioner neither fulfilled the mandate of page 51 nor fulfilled the mandate of page 56, which is submission of applications to show that they have applied. Now, in that sense, my lord, the petitioner, be it the fact that it is an ancillary or a material condition that I'll beg your lordship to go at a later point in time, the petitioner has not fulfilled the criteria laid down. Now, assuming the petitioner had fulfilled the criteria of submission of application for registering its partnership deed before the date of issuance of the LOA and after the date of closing of the tender, then I understand, my lord, that the terms of the tender at page 56 would have, to some extent, my lord, entitled the petitioner to seek a relief. Now, as I understand, my lord, there has been no violation of legal or fundamental right. Here, the petitioner is seeking relief on the basis of equity as to what prejudice would be caused to the IOCL if they are given the tender. My submission on behalf of the IOCL would be that the terms of the tender either bars or enables parties to enter into a contract with the IOCL. Now, there would be tenderers, there would be bidders or partnership firms who have not registered themselves and who have stayed back from participating in the tender because they did not fulfill the criteria on page 51 and page 56. Now, my lord, proceeding on this, the fact that there is no timeline granted under 56 would not be prejudicial to the IOCL or the petitioner, but it will be prejudicial on the touchstone of Article 14 to those tenderers who did not participate. Now, whether it is a material or an ancillary condition, irrespective of whether it's a material or an ancillary condition, they do not fulfill the criteria within 16/9/2025, which is 4 months after the lapse of the contract, the last date of the contract. And whether a condition is material or ancillary, my lord, my humble submission is that a registration certificate shows the legal existence of a bidder. I can be a Hindu.
So, yeah, so your thing is that as far as prejudice is concerned, you're saying that a lot of other people could have.
They could have participated, but they did not participate because they did not fulfill the criteria of page 51 and 56. And neither do the petitioners, admittedly, my lords. Even the petitioners not fulfill the criteria. They belatedly On 27/10/2025, they have procured the application form that they have applied, which is beyond the date of the issuance of the LOA.
Yes.
Then, my lord, I'd like to.
What are these documents?
My lord, documents, the two emails, my lord, the IOCL, which I stated, my lord, that I would not be able to file an affidavit during the paucity of time, my lord. So the email instructions are on record, my lord, that no other bidders' cases were considered or rejected
Okay.
in the same term, my lord. Then, my lord, the second case law that I would like to rely on, my lord.
Yes.
I'll keep. My lord, state of Madhya Pradesh and another versus firm Govardhan Das, Kailas Nath, my lord.
Yes.
That I beg your lordship's attention to paragraph 8, 9, 10, and 11. The undisputed facts are that in response to the notice issued by the chief conservator of the respondent firm offered their tenders for the purchase of the said forest products. Its tenders being the highest, they were accepted for and on behalf of the chief conservator. However, the tenders were, as aforesaid, made subject to the said conditions of sale and to such of the rules made by the Riva state were applicable before the said tenders could be said to have ripened into a concluded contract. They had not only to be accepted but also sanctioned by the so and so for and behalf of the state. My lord, the same principle, my lord. That the a tenderer might be the highest bidder in a tender, which is unlike the case in this writ petition. However, issuance of a final contract is subject to the conditions which are laid down. If the LOA, my lord, was absolute, that I am giving you here with the formal work order of Swati and Ridansh, a right would have accrued, in my humble submission, my lord.
So in this contract, there was no work order issued?
There was no work order issued. Because, my lord, if I take your lordship's attention to two matters that your lordship disposed of yesterday, my lord. 16/9/2025, your lordship directed the IOCL to take a stand. That's the same tender. And in that case, my lord, the work orders were issued after the LOA because they failed to fulfill the criteria of the ATS, my lord, bringing a truck from another contract.
Yes, in that case, a coordinate bench of this court has prima facie held that you have the power,
True.
right?
In that case, a formal agreement was concluded, which had given some semblance of a right that I'm executing a work. Here in this case, my lord, we admittedly, my lord, it is my stand on behalf of the IOCL that the functional department had erred in equating a registration certificate with a registered partnership deed. That was subsequently corrected. Now, if that correction, my lord, if the correction on the part of the petitioner had also happened before the date of issuance of the LOA, it would have given some semblance of a right for them, saying that because before the LOA date, I have submitted you the application to show that I have applied. The petitioner failed to do on both counts, my lord. 27/10/2025, in the month of October last year, they only applied, my lord. And the letter of acceptance was already issued, subject to fulfillment of the tender terms and conditions. That has not been done. In my humble submission, my lord, assuming it to be an ancillary condition, whether it can be waived off or not, may not be a question that my lord would like to go into at this point in time, because the tenderer, right or wrong, had laid down certain conditions. Those conditions were not fulfilled. And as such, we stopped proceeding in the matter beyond the LOA to the petitioner. That is my case, my lord. And prejudice would be caused to those tenderers who had not participated because they did not fulfill page 51 and 56. If they do that, then the floodgates would open, my lord. And they would be right in their assertion that the IOCL had granted a liberty and a right and a privilege to a party who had not fulfilled the terms of the tender. So why are we?
No, see, like their argument is a little bit different.
My lord.
See, their argument is that now, there is an object behind this plotting of this contract, right?
My lord. My lord.
So there is an object behind it. The object is to transport.
My lord.
And for this, that they have come out, they had to have competitive bids. Competitive bids. So, I mean, you want to have the lowest price. Okay, and you want to have the highest price in this case. So now thing is that object is to transport. Now, you have laid down certain criteria to be fulfilled.
My lord.
Because you need some security, right? It should not happen that in between something happened, the truck has gone, they have withdrawn the truck or whatever. Then your goods are not being transported there is some kind of stalemate happens. So like that will be prejudicial to your interest. Correct. Now their argument was that if correct, I mean there are two clauses you have given. One you have where you have stated that this certificate has to be there.
And if not,
Then
then
if not, then if you applied also, then that can be
that
given.
can be
Correct.
proved. Yes, ma'am.
Now his argument is that now I have it. So if I have it now, I am giving it. I have fulfilled all the criteria, other criteria. There is nothing. Only thing is that like, I have a registered partnership form. Only thing was that registration before the register was not done. So now they are saying that now I have it with me. So what prejudice will cause to you if you give me the contract? I mean, because they have new trucks, they have 11 or 15 new trucks. They are saying and they fulfill all other criteria. Only thing that registration was not there. So if the contract is given to him
My lord.
now at this stage, because he has participated, you have issued an LOA, what rightly or wrongly. Now what prejudice will be caused to you if it is given to him?
My lord, in my
So that is the argument. That's why I have asked you, okay, like whether the principle of prejudice will be applicable in this case or not. Once a tender is floated, there are terms and conditions.
My lord.
And the terms and conditions may be prejudicial to somebody, may not be prejudicial to somebody. Whether that is open to be argued or not, that is the question that has been asked to you.
True, my lord. True.
Correct?
True, my lord.
Yes.
In this aspect, my
Mm,
lord,
mm.
it is my stand on behalf of the IOCL
Mm.
that no prejudice is continuing or was caused because we have made.
No, what prejudice will be caused to you if it is given
My lord,
given it to him?
prejudice, the question of prejudice will arise only if the contract is granted to them in as much as third parties' rights will be prejudiced who are not before this honorable court, my lord. My limitations, my lord, my limitations is that a tender would lay down certain terms and conditions. And time is always of the essence in a tender document. Now, it is not my case that they have not.
No, it's not always time is not always in essence.
There has to be a last date for application. There has to be a last date for scrutiny of the applications of the bidders. That is my submission, my lord. The last date was 12/5/2025, and I'm stressing
See,
this.
time may not be always essence because what happens is that like, if you give a deadline,
My lord.
correct?
My lord.
In a contract, you have given a deadline.
My lord.
Now, for whatever reason,
My lord.
you kept on extending it.
My lord.
Then the time is in essence. The concept goes that just dilutes.
My lord.
That doesn't become that. Then you can't argue that time is essence because you yourself you have kept on extending. That means what? Time is not very important for you. And I'm not talking about. I'm not talking about this case. I'm talking about the principle. The
Lordship,
time is
Lordship,
essence is that is the principle. So
Lordship,
if you give a deadline, then you have to stick to it.
My
If you keep on extending it,
deadline,
then
yes.
that it becomes diluted.
True,
The
my
time doesn't remain essence of the contract.
True, my lord. In fact, the aspect of prejudice that your lordship has rightly pointed out, the aspect of prejudice vis-a-vis my interpretation of my terms and condition, the IOCL has sought to work within the bandwidth of law which has been propounded by the Honorable Supreme Court, that I cannot exceed beyond the mandate of my own book. The tender document is my own book. I set out the rules and regulations. There was a mistake of myself, my lord, and I admitting this before the open court that I had misinterpreted a registration certificate and a registration partnership deed, my lord. Those were confused by the IOCL at one point in time, which was thereafter clarified. I had proceeded to work within the confines of law which has been laid down by the Honorable Supreme Court, Mirror Development Authority, my lord. Even Ramanand Dayanand Shetty, that my learned senior relied on. It has been categorically stated that an administrative body has to be judged by the standards it seeks to profess. If my standards are the tender documents, I cannot go beyond that to grant a leverage or a benefit to the petitioner. By that clause, my lord, I'll be violating Article 14 of all those bidders who are not before this honorable court. That is my humble submission, my lord. I have moved, I have swam, I have moved, I have run within the confines of the tender document. And the finding that I have, my lord, which have negated the petitioner's expectations, have been based on the law which has been laid down. And I have not.
And your argument is that 51 and 56.
Even if
you read together, then there is a kind of timeline.
There is a timeline. In fact, I am willing to consider the aspect that if they had applied for the registration of the partnership firm even before the issuance of the LOA, then there is a chance or a possibility that there were some rights which are violated. Now, the right which they have said is they're violated, and they're basing it on the basis of an LOA, and the LOA is a contingent document subject to fulfillment of the terms of the tender. The terms of the tender contains page 51 and 56. Neither of that till the date of issuance of the LOA. was fulfilled. That is my case, ma'am.
Because
Both 51 and 56 were not fulfilled by the petitioner, pursuant to which we did not proceed ahead to sign a formal agreement with the petitioner. Ma'am, that is my case, ma'am.
I'll just give a reply if you mind understanding.
That is, if your lordship has any other query.
No, that's
that,
fine.
that is the stand of the IOCL as to why we did and what we did. And it is under the
So you are saying that you are perfectly within the parameters of your
Within the
rights,
parameters of the- yes,
rights to reject
True,
their,
ma'am. True, ma'am.
rights to reject their.
In fact, my lord, sorry,
Oh, no, please.
in fact, my lord, there was a matter where I was involved in, my lord.
Hmm?
Among the creator. Creator knows himself. Others have to be reading. So you give the other point, huh?
Now there's another coordinate
Yes.
judgment, my lord.
Yes.
My lord will kindly come to page 6, paragraph 15, my lord. In this case, what had happened, my lord, that the petitioner had not submitted numerous documents under the tender, and the respondent could not furnish a document under the tender because it was barred by law. The reason being that a balance sheet has to be certified by the CAs. That is not permissible in law. In spite of that, the Honorable High Court, my lord, at page 15, my lord, paragraph 15, my lord, at page 6.
Mhm.
In the case of Ramana Dayaram Shetty versus International Airport Authority of India and others, reported in so-and-so, the
Yes.
Supreme Court has held that it was a settled rule of administrative law that an executive authority must be rigorously held to the standards by which it professes its actions to be judged, and it must scrupulously observe those standards on pain of invalidation of an act in violation of them. 16. In the case of Meerut Development Authority versus Association of Management Studies and another reported in so-and-so, the Supreme Court has held that the terms of the invitation to tender cannot be open to judicial scrutiny because the invitation to tender is in the realm of contract. However, a limited judicial review may be available in cases where it is established that the terms of the invitation to tender were so tailor-made to suit the convenience of any particular person with a view to eliminate all others from participating in the bidding process. It is further held that the bidders participating in the tender process have no right except the right to equality and fair treatment, free from hidden agenda in the matter of evaluation of competitive bids offered by interested persons in response to the NIT. Thereafter, my lord, will kindly come to the last page, my lord, paragraph number 20.
Yes.
In view of the reasons stated above, the matter is remanded back to the state respondents to consider as to why any other valid tenderers whose bid can be considered for, sorry, I apologize, my lord.
Whether-
Paragraph number 19, my lord, 19.
Mm.
In that view of the matter, the court finds that the award of license to respond number 5 could not have been done by violating an essential condition of the tender. Further, there is no challenge to clause 2.1 of the bid document by any of the parties. The allotment of the IMFL retail off license to the respond number 5 is accordingly set aside. Respond number 5 had failed in only one aspect of not submitting a balance sheet certified by CA. Even then, in that aspect, the Honorable Court went ahead and set aside, and my lord will kindly see, there is no challenge to clause 2.1 of the bid document. In this case also, the petitioner has not challenged the clauses based on which you have taken the decision. So at the very basic onset of this matter, my lord,
56 is not challenged.
56 is not challenged, 51 is not challenged, my lord. So in the absence of challenge to those rules under which you have taken the decision, my humble submission, my lord, that the petition may not be maintainable, my lord. That is the stand of the.
Yes, yes, sir.
I'm grateful, ma'am.
I'll just give a reply, my lord.
Yes,
A
yes.
reply.
Yes.
I'll just start from where he ended.
Mhm.
Where he ended, I start.
Mm.
These two, the judgment, last judgment is not applicable in this case. Now, your lordship has put a very pertinent question regarding prejudice.
Mm.
How it will cause to them
Mm.
if they allow me.
Mm.
That's what your lordship has asked, my learned friend. My learned friend, what was his reply?
Mm.
His particular reply was that if some bidders would have participated, that cannot be Article 14. Some bidders would have participated, then this clause, which has been, they have incorporated, they did not participate because of this clause, what he is saying. So that cannot be in case of Article 14. Article 14 is something else. What your lordship is precisely putting to my learned friend, where are those bidders who participated and where you rejected on this particular clause? Then there cannot be an exception to this petitioner, neither your lordship cannot allow me, because it will violate Article 14. You cannot, my lord, anticipate. He is anticipating. If some bidders did not participate, some bidders could have participated. They did not participate of this page 56. That is not a concept of Article 14. Now I'll straight reply second. What is Dayaram Shetty's case? Dayaram Shetty's case is the person has participated. And the Supreme Court said that where is the eligibility criteria? How you allowed him? He did not have the experience for running the restaurant in airport. He may have an experience. That has prejudiced the other tenderers who could not have participated. That is not the case, my lord. What is citing? Mirror development is something else. Mirror development is how tailor-made to suit a particular tailor, to suit a particular bidder. So this particular decision will not help. Second, my lord, the prejudice part, my learned friend has failed to show before this court that it has prejudice, it will prejudice them because there are other bidders similarly situated with us, like the petitioner, and their bid was not considered on this ground. Then neither, my lord, then there is no question that your lordship will consider it because they have rejected. So this is one on prejudice. Second is, my lord, which is most important, is a technical evaluation committee. A delegation has been, they have delegated a power to a technical evaluation committee. Once the technical evaluation committee has taken a decision to the extent of the issuing of LOA, where is the question? Because they become functus officio. Where is the question of you overturning it and saying that no, they were wrong, somewhere wrong? Can you do it? Delegation has been given to that tender evaluation committee. And that was a logical conclusion up to the LOA. Now, please see, my lord. The closing date of the tender was 12/5/2025. That was the closing date. When they made a query, 14 June 2025. Please see the query they have made before the issuance of LOA. That's the striking point which I have seen where my learned friend today, he has briefed me and where I am placing it. Please see the query that has been made by them before issuance of LOA at page 140. 140. Please see that. My lord, prejudice, I have given an answer to it. That's not applicable. Prejudice. They could not satisfy the court. Neither they could not place any document before the court. Now see the next point.
Yes.
My lord, 140. Which is the date, my lord? Date is here, 14/6/2025.
Where is the date written?
14/6.
It's an email,
Not
right?
written, yes.
Hmm.
My learned friend has confirmed it is 14/6. 14/6/2025.
14/6, but date is not here.
No, my lord, but
Hmm?
there is no dispute to that, man.
But date is not written
There
in
is
this
not-
document.
There is another, there's another preface to this actually, my lord,
Okay.
which has probably not been.
So this is on 14.
14/6.
And the last date of closing was 12/5/2000, right?
12/5,
12/5/2025. Closing was 12/5/2025.
Hmm.
And my lord, this was on 14/6/2025 where the queries was made.
Hmm.
Right, my lord?
Hmm.
See, my lord, what the queries they made. One, queries, major activity so-and-so, integrated pact. Number 3, copy of registration certificate from register of firm to establish the registered partnership firm enclosing all annexure wherein the names of all the partners of the same partnership firm are mentioned to be submitted. Right, my lord?
Hmm.
Now, please turn to page, my answer, 156. Please see 156. Yes, 156 is the affidavit which we have filed,
Hmm.
which we have given a reply to them. 156.
Hmm.
Paragraph 1. See, my lord, paragraph 1. That Messrs. Swati Logistic is a registered partnership firm which has been registered before so and so, as per provision followed by Government of Assam partnership deed dated so and so. Further, the said registered firm has duly been digitally signed by sub-register office of so and so. A copy of the said registered partnership was already uploaded in the bid, and I'm again submitting the partnership deed along with this affidavit for your kind perusal. So before closing date, my lord, before closing date, the partnership deed was before them.
No,
Registered, it was registered. Now please look into
no. This is registered before whom?
registered or sub-register.
Sub-register, not before the register of partnerships.
That's right.
That's not
The
there.
sub-register.
No, this is not they are disputing.
No. What I'm saying,
Hmm.
they have made it. What my queries, my answer to it. The closing date was 12/5. 14/6 was the queries they have made.
Hmm.
I have given all the answers to them. All the answers.
No, you have not given the answer.
No,
I mean,
no, I have-
answer is
no.
answer would have been the registration certificate from the registrar.
Let's see. Let's say that I have not given answer.
Hmm.
To that extent,
Hmm.
why they said,
Hmm.
and why they have issued the LOA. Now let's say when the LOA issued.
The LOA has been issued. I mean, they are saying that there was a mistake.
Now I'll give an answer to it.
Hmm.
If the LOA has been issued on 16/9/2025,
Hmm.
and my queries was on 14/6/2025,
Hmm.
then from 14/6/2025 till 16/9/2025, why you have not issued any email or letter to us saying that this being in compulsory nature, why you have not submitted this particular register of certificate of forms? Why you have not?
Correct. So they are admitting that there was an error on their part. They misinterpreted this document. Now tell me one thing.
Yes.
Now error has been committed by them. There is no dispute because they have admitted it. They have admitted it. There is an error. Now whether it can be rectified or not.
No. Now I am telling you. Which particular date they have come to the court when? They did not communicate to me at any point of time. This is the first time stand which they have taken in the first round of litigation. My lord will kindly, look in this way. I would have very well accepted that if this particular stand has been taken by them before coming to the court. We came to the court, thereafter this stand was taken. This stand was taken before this court. Why they have not taken a stand earlier before issuance of LOA? That sorry.
I mean, there
we
was no
can't issue-
communication from their side, right?
No.
There was no communication at all.
No. That's our case, my lord.
Hmm.
Then why you have issued this LOA?
No, after issuance of the LOA, what was the communication they have done? They haven't done anything.
Not done.
So they were not issuing the work order. That's why we have come to the court.
Yeah, I have come to
Then
the court.
first round you came
Yes.
there. Then what happened? Then you have
Then-
been sent back.
Yes, they have sent back.
Hmm.
And for the first time
Hmm.
in the order that has
Hmm.
been communicated to me,
Hmm.
in pursuance to order that has been passed by the court,
Hmm.
they said that no, this technical committee doesn't have that legal understanding of this. That's why they have done it.
Hmm.
First time they have taken. Why you have not communicated to us saying that we cannot issue an LOA because this is a mandatory clause. They know, that's my answer, that this is not a mandatory, this is an ancillary. And if you read the clause 51 and 56, you have to read harmoniously. That's why this exception was carved out and saying that, okay, there is because there are a lot of bidders who may not register under certificate of firms. So that exception was given by them. My lord, I am asking myself, what is the difference between the certificate which I have not given to them and those bidders only has given an acknowledgement slip? They did not have the certificate.
But do you have any? I mean, do you have any material before you or with you that anybody similarly placed have been given work by them?
No, we don't
You
have.
don't have it.
But your lordship has asked them a very pertinent that Article 14, you show to us, is there any bidders on the same ground you have rejected? Today also my learned friend is saying no. Perhaps there would have been other bidders who may not have qualified. That's why that particular Article 14 is applicable. That cannot be, my lord. To my humble submission, that cannot be. On the face of it, they have to show it. Now, if your lordships, now what is your lordships fallen from your lordships now? See, I have given a note of it. The other side of it. My lord, see the note.
Yes.
These are the queries that has been made.
Yes.
See this first query, which is made on 24/4 the Honorable sought clarification of the following aspect. Please correct me, my lord, if I am wrong.
Mm.
A object sought to be achieved by tender floated by IOCL. Correct, my lord? That's what. IOCL floated a tender for bulk transportation of so and so. The criteria of evaluation is based on age of tank truck. Number B, state registered tank truck would be given preference. C, 7 metric ton tank truck would be compared against other bidders who have submitted below 7 metric ton. The first one. So now, my lord, this is the object to be achieved by them. So these are the criteria. Now, for a moment, my lord, age of tank truck. Now, suppose there are some bidders where the age of tank truck, where I have given a new particular, all these tank truck are new. So the safety has to be looked into it. Now, there are some particular bidders who has given, there is a timeline within 14 years. Now, suppose a bidder has given some trucks, but that is older than me, then they will evaluate whose.
So priority will be given to new ones. Right?
This is what are the criteria.
Mm.
Now, see one judgment.
Mm.
Huh? We have given one judgment of Meghalaya High Court also.
Yes, yes.
Yeah, the other side it will be.
The Mag India.
Yes. Please look into it. What is that? We have given that particular. Please see my note, my lord.
Yes, yes.
See, WPC so and so,
The
Mag India Medical, your lordship got it?
got it.
Medical so and so, the state issued an NIT for inviting bids for installation of a MRI machine. The bid evaluation criteria specifically mentioned that lowest rate is not the criteria for evaluation. Rather, the contract will be awarded to bidder who can provide the best quality product and services, including training. In a caption tender as well, a price is not the criteria, and the IOCL is desirous of having tank trucks which are new so as to enable carriage of LPG, which is a hazardous cargo, in a safe manner. This is what they want. Today, they can't say, we'll reject because of this particular clause. And that clause also is not mandatory.
Which para you are referring to in this case? The Meghalaya case?
We are
Mag India?
referring- Yes. Para 13, my lord. See, this para 13. Please read para. I will read para 13, my lord.
13.
1-3. Lordship got it?
Yes, yes.
From the narrative as given above of the events that has occurred, it would seem that a tender process in the normal course of business would have concluded with the selection of the product of the petitioner.
Mm.
Notwithstanding the cost for which provision has been made in the bid document itself, that the lowest rate was not to be criteria for evaluation. Rather, more consideration would be given to the bidder who could provide the better product and services. However, it is seen that the respondent number 5 by 6 by letter dated address a letter to respondent number 5, that is Deputy Commissioner, requesting his attention to the bids on the ground that they were the lowest bidder. Therefore, wide letter dated 19/12/2023, respondent number 2 on the direction of respondent number 5 invited tender and technical expert committee others to attend a meeting on 21/12/2023. Now what? Now, my lord, what is the case? My lord, the technical evaluation committee who has evaluated, they on the basis of that calling for another meeting, they again re-evaluated. So the court said that how can you? They have become a functus officio. Where is the question of re-evaluating again? Please see that. Which is the paragraph? Please look into that, my lord.
Which para is this?
Yes. Please see 14. Please see what unfolded thereafter, as can be seen from minutes of meeting, is that respondent number 5 chaired the said meeting in his capacity as a chairman of the Hospital Management Society and embarked upon the exercise of examining the comparative statement and presentation of the product against the required specification. Thereafter, as the chairman, concluded that respondent number 6, being the lowest bidder, was preferred for procurement of MRI machine. This decision thereafter culminated in issuance of a work order dated 9/3/2024 in favor of respondent 6. From the proceeding, it can easily be discerned that the decision of a duly constituted tender committee with expert members had been superseded by decision of the Hospital Management Society under the chairmanship of respondent number 5. From the recorded minute, it is also relevant to note an expert of so and so who was a member of tender committee who has given an expert opinion as to the suitability of the petitioner. Tender opening meeting was not present. In this scenario, court need not go for to arrive at a conclusion whether the impugn action of respondent in reversing the decision is sustainable in law. So, my lord, what is our case? A tender evaluation committee, you have delegated that power. Tender evaluation committee has gone through it. Now they have made certain queries also. Now, after the queries that was made, LOI was issued. Now, this particular, my lord, points come in C. Please see, point C in my note. Point C in my note. Whether the decision of the scrutiny committee can be substituted, overruled after such committee has become functus officio. In the present case, the work of the scrutiny committee commenced upon submission of bids by all bidders. Once the technical bid was accepted, it meant that the petitioner had passed qualified the test of scrutiny committee, and as such, the scrutiny committee became functus officio. In Bharat Kushan, there is one judgment of Himachal Pradesh, my lord, that I will place it before this court, my lord.
Yes.
We have given a copy.
Yes.
Give a copy to the answer.
Thank you.
Let me see. Paragraph, my lord, 7. Paragraph 7, my lord. See paragraph 7, my lord.
Yes.
Paragraph 7, please turn to next page, my lord. Paragraph 7, next page.
Yes.
Roman 3 and 4. Roman 3 and 4.
Yes.
The Technical Evaluation Committee, while evaluating the technical bid of 6 participating bidders, were very much aware that the technical bid submitted by tenders has some defect. Still, it thought it prudent to ignore the defects and took a decision to accept the technical bid of 6 participating bidders. This decision was taken into its logical end and was notified to the bidders. So, they also know, my lord, this defect, your lordship has whether this defect is curable or not. Whether your lordship has put a very pertinent, whether this defects is curable or not. They have looked into it and they know there's a curable. That's why before issuance of LOA, these queries were made. And why I'm asking, why they have issued an LOA? They could not have issued an LOA saying that we are not issuing an LOA because this clause is mandatory. They know, my lord. They are taking the plea now that they are not aware, legally they are not sound or equipped. That's why they have, so they are overturning now. Now see 4, my lord, 4. The Technical Evaluation Committee, after evaluating the technical bid on 6/4/2023, become functus officio. There is nothing on record to indicate as to why it reopened the technical re-evaluation of the bid submitted by tender on 26/4/2023. Action of the Technical Evaluation Committee in reviewing its earlier decision on 6/4/2023 is without any basis whatsoever. There was no occasion of the aforesaid committee to re-evaluate the technical bid. No such direction issued to this committee, either by respondent or by court in the writ filing a tender in question was brought to our notice.
Correct. Now, the thing is that in your case, there is nothing to show on record that there was any re-evaluation made, there was any committee set down,
Correct.
nothing.
Correct.
So when you came into the court, the stand has been taken,
Stand has been
and they were totally silent why the work order was not issued.
Yes, correct.
Mr.
That's
Sharma, you'll have to answer this. I mean,
My lord, there's one query, my lord.
Mm.
My lord, sir, one large judgment. Similar case, my lord, whether there exists any consequence, see the reference B, my lord. Reference B of my note.
Yes.
This is the Karnataka High Court.
Yes.
Whether there exists any consequence for non-registration of partnership form of petitioner before the register of firm. Right, my lord? This is what they have rejected, my lord.
Whether there exists any consequence of non-registration of partnership form. Oh, okay. The legal this thing.
Yes.
Okay.
Para 13-14. This is Karnataka High Court, no? Same issue, my lord.
But in a tender process, Mr. Das, again that the issue will come whether in a tender process, the court can go into those issues aspects.
See, my lord. Second issue, my lord, however, having accepted, note, having accepted,
Yes.
having accepted the reply,
Hmm.
IOCL issued the LOA on 16/9/2025.
Hmm.
In a similar case before the Honorable Karnataka High Court, the question which arose for consideration was whether non-submission of certificate issued by register of firm would disentitle the petitioner therein from participating in the bid floated by IOCL for road transport in the bulk petroleum product. Same from so and so to retail units under jurisdiction of so and so. The Honorable High Court held IOCL was not justified rejecting the bid, since it was not the case with IOCL. Without having the said certificate, the petitioner disqualified from participating in the bid because that exceptional clause was given to them.
Okay, let us go to that particular facts of the case.
Yes. My lord will kindly see paragraph 2. Paragraph 2.
Yes.
Petitioner is a registered partnership firm involved in the business of transportation of petroleum product. Respondent number 2, Indian Oil Corporation invited tender for road transportation of bulk petroleum product from so and so under jurisdiction to
So same kind of work, same kind of
Same.
scope of work. Yes.
Yes.
Hmm.
Now, if you see
Hmm.
para 3 clause is there, para 3.
Yes.
Para 3 subclause kindly see, page 3. Tenders are required.
Hmm.
Tenders are required to submit copy of registration certificate from registered firm to establish the registered partnership firm enclosing all annexures wherein names of all partners of the said partnership firm are mentioned or certificate of incorporation. Similar, my lord. Right, my lord? Now, please see now paragraph 13. No? See paragraph 13, 14 now.
Yes.
The clause pertaining to the requirement of partnership firm requires the bidder to submit copy of registration certificate from registered firm, registered partnership firm. Same has been produced by petitioner. It also requires enclosing of all annexures, my lord, see my lord, wherein the name of partners of partnership firms are mentioned and the petitioner has submitted deed of partnership itself will reveal the name of partners.
Hmm.
Here, my lord, deed of partnership registered also mention who are the partners here. Any reasonable prudent person reading the said clause will understand that if the documents submitted by the petitioner sufficient, if respondent number 2 was particular about production of so and so, a form A, issued by register of firm, it should have specifically stated so. Not having done, the respondent is not justified in rejecting the bid of the petitioner on the sole ground of not producing issued by register of firm. It is not the case of respondent of the petitioner is not qualified to make the bid. Same here also, my lord. So what was they have given exception 51 and 56. You read that exception was given by them. This is the order that you are participating. But my lord, here
But
in this
but
case,
here in 14,
yes,
in para 14, any reasonable prudent person reading the said clause will understand that if the documents submitted by the petitioners are sufficient, if respondent number 2 was particular about production issued by the register of firms, it should have specifically stated so. But that has been stated here.
yes.
In clause 3.
Here, my lord, what is not after LOA? LOA has been issued in this case, my lord.
No, correct, Manan. What I'm asking
No.
is that, I mean, whether this proposal, this is correct, because in the clause, tenders are required to submit copy of registration certificate from register of firms, correct?
It already
Now here, if the respondent number 2 was particular about production, production of form A issued by register of firms, it should have specifically stated so. But it is specifically stated so here.
no. What is
But
our
in this
case?
case, I mean, in
Yes.
this case, I'm talking about.
No, in this case, what it has not been form A or the annexure, it has, if that was mentioned, then it would have a different case altogether.
All these details and all.
Now,
Yes.
now my the case here is a case where before the financial bid was open. Number 2, in our case, some exception was given which is not in this case. That is, my lord, the 3, clause 3, 4, Roman 4. That exception was given. Here the exception was not except all the particulars form A.
34856 you are saying, page
56.
56, yes.
That exception was given. If that exception would not have been given and you read only page 51, the situation would have been different, it would have been mandatory. That exception was given because they also knew that some bidders may not have that certificate of forms. My lord, I am asking myself, what is the difference between non-submission of that certificate of forms, no? Certificate of form registered, non-furnishing, and those bidders, only the acknowledgement slip has been given. They have also not submitted. Am I clear, my lord? This certificate of firms, which is registered, some bidders, that exception has been given because they knew that bidders may not have.
A situation may arise that somebody has applied for this, but still they are awaiting that
This
certificate.
awaiting.
But,
So
but,
how-
but they have been given the contract.
Then, my lord, how it makes a difference? I have not submitted, but today that particular formality has been done.
Correct.
And last I'll give a reply.
Mm.
See now, page 41. See page 41 of the tender. See page 41.
What about this, who has submitted this dresser?
I have done that.
You have. And Mirat Development you have given?
State Development, Ramana Dayaram Shetty, my lord,
Ah,
Dresser and State of Madhya Pradesh versus firm Govardhan Das Selasna and my lord Maharshi Dayanand University.
So you'll have to give the paragraphs of these cases.
I have
eh?
done that, my lord. I have.
Yes. You have given me the copies, but like
And paragraph also.
paragraphs. Okay.
Please see page 41 now, man.
Yes.
This 41, 11, serial number 11.
Yes.
The expected date of start of contract.
Mm.
Now, on the right-hand side column,
Mm.
what is this, my lord? From the date mentioned in the LOA. Oblique LOI. Now, if you see page 171.
One.
71 is the LOA. Letter of acceptance.
Yes.
'69 at 171.
Hmm?
171.
Hmm.
41 has to be read with page 171.
Hmm.
Either it starts expected date of start of the contract from the date mentioned in the LOA and LOR. So my offer has been accepted by them by issuing the LOA. So kindly see at page 41. Expected date of startup from the date mentioned in LOA/LOI. So you have letter of acceptance, you have accepted my offer. Where is the question? Now you are turning back and now you are saying that this document is not there. This document is not there. Where is that? You did not say anything to us. Why you have, we waited, you waited me to come to the court. Now you are taking that stand. And you see page 175. Please see 175 of LOA. As per terms and you are advised to carry out the following. They have gone to such an extent, my lord, such an extent that my financial bid you have accepted, but technical bid is accepted, financial bid is accepted. You waited for 2 months. You didn't communicate it as per your queries that has been made, and thereafter you issued the LOA. And at 175, we have performed 1 and 2. 3 we could not because only they have not given to us. 4 is to submit document, declare depositable tender, complete all respect to office of following address. So, meaning thereby, my lord, this particular document which you have not submitted, that also could be submitted. They know very well. Now they take a different stand in the court. They take a different stand in the court.
So the document you have submitted when? When did you submit the document?
Yes.
Or you didn't get an opportunity to submit? Did you get an opportunity to submit
No,
the
no.
document? No, you didn't get. You
Yes.
have not been given an
Yes.
opportunity.
And please see 177. Yes, please see 177. 177, date of filing or registration. This is 27/10/2025.
Mm.
See 27/10/2025.
Yes, yes.
Yes.
After the LOA, my lord.
So now please look into it. Please see of
See,
69.
LOA also, Mrs. Sharma,
30 days.
LOA also, you have stated that certain documents should be, has to be
30 days.
submitted. So that you should have given opportunity to submit him the document.
I have submitted.
Why you have not given?
No.
30 days.
My lord,
30
the
days.
LOA, my lord, the LOA.
I'm
I'm sorry.
one.
I just give a reply.
Mm.
Within 30 days, I have to submit.
Mm.
And this I have done. Kindly see at page what is there?
Sorry?
39 days, 9 days. This is not the ground. They could have rejected and said that no, we are not.
No, when did you submit? When did you submit?
27/10.
Oh, no, you got the document, but you
Yes.
didn't get the opportunity to submit. You have not submitted it.
No,
That's what I'm asking.
that's what.
Mm.
We were waiting for that, my lord.
Mm-mm.
My lord.
And the judgment.
See,
which my
now only thing, Mr. Das, you have completed?
I've only the judgment which my learned friend has shown, the first judgment, that's a formal work order has not been issued. Then the court said that it is under arbitration. They have appointed an arbitrator.
No, now
Arbitrator
he has to answer one thing. The first thing you'll have to answer, see, in the LOA, you have specifically stated the documents that you argued also, that the other day you argued.
My lord.
The documents were not completed, he has not submitted the documents. Now, thing is that whether you have given any opportunity to him.
My lord.
So
Answer-
you were saying that within 30 days, those were not given. Is it your stand?
My lord, no. My my
No,
concern
no,
is
see,
lordship's query, my lord.
no, see, LOA, you see the LOA.
Yes, my lord.
Okay, in LOA,
Yes, my lord.
that you have read out, that you have argued that
My lord.
certain, it is a contingent document.
Yes.
It's a conditional LOA that
My
you
lord.
have stated,
My
right?
lord, my lord.
And conditions are laid down here,
My
right?
lord, my lord.
So you have not specifically mentioned about that particular condition. That's okay, fine, that's fine, we have accepted.
My lord.
That will include this. So now you see that to submit, see number 4, to submit the documents, declaration, deposit as per the tender,
My lord.
completed in all respect to the office of the following
Following
address.
address, my
Then you have read out the contract will be guided by terms and conditions, fine, the formal order will be done so and so.
My lord.
Now, execute standard agreement within 30 working days of from the date of LOA.
Which was never given, my lord.
So now whether it is your argument that if it would have been given within 30 days, then you would have considered it.
I'm sorry.
Mm, mm, mm,
Sorry.
Mm.
C 176 and C.
Mm.
C.
mm.
Effective date of start is 1/9/2025.
Yes.
That is 10.
Mm.
And the LOI is 69.
Mm.
Then
Correct. So that was what this court is asking.
My lord.
You have stated that to submit all the documents.
My lord.
So you have given an opportunity to him, that
No,
means.
what happens, my lord, in a tender that your lordship would also be aware that initially in tender floated by the oil marketing companies, initially the physical inspection of the trucks are carried out. And thereafter, my lord, after technical verification is passed, thereafter the documentation is carried out. Now, my lord, 175.
Mm.
There, your lordship would see there is some similarity, my lord, between point number 2 and point number 4.
Mm. Correct.
Physically place all the ready-built TTs at the location of physical inspection with all licenses and documents for original verification.
Mm.
And number 4, my lord, to submit the documents / declarations deposits as per the tender completed in all respects to the following at the following address.
Mm.
This should imply, my lord, submission of those documents in hard copies for the verification of the IOCL. Now, when this LOA was issued, the LOA was issued looking into the suitability of the trucks provided by all the tenderers. Thereafter, the final work order is issued. Now, your lordship is aware of the formal work order in case of the matters yesterday, my lord. They were issued 10 days thereafter. Now, when this LOA was issued, the LOA was also subject to the requirement of the petitioner fulfilling all the requirements. The petitioner, assuming under 4, was supposed to abide by the terms and submit all the documents, they could not have satisfied the mandate of the tender document on 16/9. Even on 16, even 30 days thereafter, my lord, executes standard agreement with 30 working days. The 30 days from date of issuance of the LOA will be 15/9. They applied for the registration license on 27/10, and my lord will kindly come to page 140, my lord, where my learned senior is relied. Page 140. Page 140 for a moment, my lord.
Raise one.
140, my lord. The query that we raised, 14/6. The third point, my lord. Copy of the registration certificate from Registrar of Firms to establish the registered partnership firm. My lord, we had sought the registration certificate in our query. We were categorical. What happened thereafter was part of our misunderstanding of law of the functional department.
But you have not communicated to him. Why?
Eventually, it was communicated, my lord.
No. I mean, as far as this, after the issuance of the LOA,
My lord,
you never communicated to them. You never communicated to them that because of this, work order could not be issued to you.
now, my lord, if me not communicating that aspect to the petitioner, I ask myself, my lord, whether prejudice would have been caused to the petitioner had they had the registration certificate or the acknowledgement slips prior to 16/9, then there would have been a case of the petitioner that they had failed in fulfilling documents because I failed to ask. Now, had I asked upon issuance of the LOA that kindly provide me the documents under page 51 or 56, I asked myself, my lord, based on the acknowledgement of 27/10, could the petitioner have satisfied the terms of the tender, my lord? They could not have. Me asking a question is a moot question, my lord. If I had sought from the petitioner, please kindly give me the acknowledgement slip, based on what is on record, my lord, they could not have abided by the condition. 51 or 56, they're saying that I did not ask. Assuming my lordship will turn back the clock, and then 16/9, your lordship directs me that IOCL should have asked that query, kindly provide all the documentation. Would they have been able to satisfy that, my lord? They would not have been able to satisfy. And my lord, my senior has relied on Meg India, medical supplier, my lord. My lord, paragraph 15, my senior has read. In this scenario, this court need not go far to arrive at a conclusion as to whether the impugned action of the respondents in reversing the decision is sustainable in law. Now, my lord, from the conditions of the NIT itself, which has been quoted above, firstly, it has been provided that the lowest bid would not be the only consideration for acceptance, which is further reinforced by the clause with regard to bid evaluation.
Yes.
Secondly, clause 15 has categorically provided that the decision of the committee on technical suitability shall not be open for discussion. This clause is absent in the current tender. Now, my lord, what has transpired, however, is that the respondent number 5, as chairman of the Hospital Management Society, has literally reopened the technical evaluation and awarded the tender to the respondent number 6, and has even gone to the extent of recording his opinion as to the virtues of the MRI offered by the respondent number 6 in his affidavit at para so and so. I ask myself, my lord, have I re-evaluated the credentials of the petitioner? The answer is no. Have I misunderstood something?
But you have reopened it.
I unfortunately, my lord, I have
re-scrutinized it.
Yes, my lord, I have misunderstood my own mandate. That is something that I'm admitting on oath, my lord, before this court. But am I revisiting the clause? Am I reassessing his own suitability? No. The question that would fall for your lordship's consideration is if on the date of the LOA, I would have asked or posed that query before the petitioners that Swati and Ridansh kindly provide me the acknowledgement slip or the registration certificate. Could they have complied with it? The answer is no. Thereafter, my lord, as held in the celebrated case of Tata Cellular versus Union of India, in such matters, the Supreme Court at para so and so, which is relevant as hereunder, has held. The duty of this court is to confine itself to the question of legality. Its concern should be whether a decision-making authority exceeded its powers. My humble submission, my lord, no. Committed an error of law. We corrected the error of law, my lord, vis-a-vis the comparison of a registration certificate of the registered partnership deed. Committed a breach of the rules of natural justice. My answer, my lord, would be no. Reached a decision which no reasonable tribunal would have reached. My answer is no. Abused my powers. I have not abused my powers. Therefore, it is not for the court to determine whether a particular policy or particular decision taken in the fulfillment of the policy is fair. The object of a tender cannot override the terms of a tender, my lord. Otherwise, the sanctity of the terms and conditions would lose its value in its entirety. It is only concerned with the manner in which those decisions have been taken. The extent of the duty to act fairly will vary from case to case. Shortly put, the grounds upon which an administrative action is subject to control by judicial review can be classified as under: first is illegality. There is no illegality, my lord, in law. Irrationality, no irrationality. And procedural impropriety, we merely corrected a wrong which was done by ourselves. And there is no estoppel in law, my lord, to correcting an illegality. The only question that your lordship would kindly like to ponder, my lord, is whether your lordship would allow perversity to prevail in this tender by allowing this petition. That is my submission. Nothing else. I'm done.
Okay. So we'll close this, we'll pass this as order adjustment. Heard Mr. D. Das, the learned senior counsel, assisted by Mr. C. Garg, the learned counsel appearing for the petitioner. Also heard Mr. M. Sharma, the learned standing counsel for ISTL, and Mr. S. Roy was appearing. Who is appearing for the? Okay, right, her name. For respondent number 1. Hearing concluded, judgment reserved. So now the contract has started, right? I mean,
separate work orders have been issued to other
and term is for 5 years.
5 years.
5 years.
5 years.
Okay.
But your lordship, I have shown that day. There are balance truck also is available.
Now ad hoc basis
Yes,
it is
that's
going
right,
on.
right.
Ad hoc basis going on, term is for 5 years.
5 years. 5 years.
So if you, I mean, without commenting on anything, if you succeed, then you can be given. And
Yes.
if you are, but there is time.
Yes.
There is time.
But it
Correct.
does not impair our operations, my lord. Subject to this, we have only issued the ad hoc arrangement because this matter is sub judice.
That's
Matter
right.
was sub judice.
Because it is sub judice, my lord. Reversing a decision would entitle.
So no third party right or
That
whatever.
is the reason that we have not given assured anybody of any.
So that hasn't been created as yet, or that's what I wanted to understand.
Subject to what your lordship will finally decide, my lord.
Yes.
I'm deeply obliged.
Yes, yes. Stop, huh? Oh, with the same.
May I please your lordship? Lordship, here is the petitioner, lordship. Petitioner as the legal heir of the Pune Mess Paul was a policeman, lordship. Who- Petitioner wife, lordship, who died due to COVID-19 while serving.
Now, what is there any instruction affidavit?
Receive
What?
an instruction, Lordship.
No, no, what instructions you have?
Lordship,
No, why don't you file affidavit?
we have
You
received,
take time for affidavit file to file affidavit and you don't file it. I mean, what is this tradition and bringing in these instructions? In spite of receiving the instruction, you don't file affidavit in time. Now, always I have seen, I mean, for last couple of weeks, I have seen that you receive the instruction, you don't file the affidavit.
this is instruction was received, marked to the another council, Lordship. Today I am appearing, Lordship.
No, mark to the different council, that
Today
is
I
not
have
an
received,
excuse.
Lordship.
Whoever it is. I mean, on the basis of instructions, the court cannot pass order always. And if there is some urgency, there is certain
As
things,
per
then
the
it's
instruction
fine.
received, the matter is referred to the judicial department.
So give me the instructions. So that will not do. Judicial department, I mean, was it sent?
There is a report, Lordship, from the.
Now,
court hearing
when
has
was
been-
it sent to the judicial department?
that
It
is-
was in, this notice was issued on 12/6/2025.
It's been more than 5 years, lordship. They have
One
not.
second.
Non-COVID death, Lordship, as part of report, Lordship.
What is the amount? 50 lakhs for
50
COVID?
lakhs.
Huh?
50 lakhs.
50 lakhs.
50 lakhs?
Yes.
Lordship, may page number 4.
No, you have taken a very strong stand. There is it's a non-COVID debt.
Lordship.
Then you should file an affidavit there, so that he can file a reply to this. You have taken a stand, and this instruction has come on 3/10/2025.
Lordship,
Now 6 months have elapsed.
Lordship, for a moment, kindly come to the page number 32, Lordship.
Why?
Lordship, they are saying that it's a not COVID, Lordship.
Yes.
But later, Lordship, the,
No, I mean, are you not allowing them to file affidavit? You want to dispose it of now?
no, Lordship.
Then they are taking a stand that it is a non-COVID debt. So I am asking them to file an affidavit saying, bringing on record, why is they saying so? So that like they can bring in some documents, okay, you can reply to it. Now, if you want to argue it now, then then argue.
No, Lordship.
When can you file the affidavit?
After 2 weeks, Lordship. After 2 weeks, sir.
Okay, heard Mr. So-and-so, the learned counsel appearing for the petitioner. Also heard Ms. G. Hajarika, the learned counsel, learned government advocate appearing for
Respondent number 1, Lordship.
respondent number 1. MSG Hajarika submits that she has received instruction in the instant case and would like to file an affidavit in opposition and prays for 2 weeks time. 2 weeks time is allowed. Let the matter be listed after 2 weeks. In the meantime, no, let the matter be listed after 3 weeks. If file within 2 weeks. In the meantime, if the counsel, in the meantime, after filing of the affidavit in opposition, the counsel, the petitioner is at liberty to file affidavit in reply if so advised. Let the matter be listed after three weeks.
Yep, yep.
Only one, plus the date may be fixed.
No, 3 weeks. Let them file it, then you'll have to file a reply. What the point of giving a date now?
4 and 5.
Will be the person.
Mm.
In item 4, Lordship, I need some more time to file affidavit. And in item 5, your Lordship may dispose it up as because they have already considered my fatta. And it is at the stage of issuing fatta to the petitioner, Lordship. Revenue records were already corrected after filing of this.
Item number 5.
Yes, Lordship.
Item number
Thank
5,
you.
you are saying you have already, this,
Revenue records already
Yes,
corrected.
Lordship.
And they are pursuing the matter of issuing patta, Lordship, under the consideration of DC, Lordship. So if your Lordship, on last occasion, your Lordship said that Lordship will dispose it of.
yes.
So 3790, Lordship may direct that they may issue patta to me, Lordship. Allotment already approved, Lordship. I have filed the premium also. Revenue records were also corrected in my name. Annexure 1. page
Right,
12 is the-
in this item number 5, that 3790. Heard Mr. MS R Chaudhary, the learned senior counsel, assisted by so-and-so. For the petitioner, also heard Mr. SK Hajarika, the learned government advocate, appearing for respondent number
3, 4 and 5.
3, 4 and 5 and G Hazarika for 1 and 2. The petitioner's case petitioner's case is basically is that the petitioner being a landless person applied for allotment of government caste land covered by DAG number 2 situated at village Garamari part 5 under Gauripur Revenue Circle. Accordingly, his contention is that he has been residing in the same plot of land for last 45 years. 45 years, and he has applied, he has been accorded approval for allotment of the land by the Deputy Commissioner Dhubri, white letter dated 3/6/2024. Accordingly, he has applied before the concerned authority for issuance of patta with due payment of the premium. However, the petitioner was not allotted any patta, and being aggrieved, the petitioner has approached this court. MS Chaudhary, the learned counsel, learned senior counsel, appearing for the petitioner, submits that though the issuance of patta was stalled for for some time due to certain technical defects, now the digital portal has already been opened and the process of issuance is going on. Is it correct?
As per their.
Correct? Going on, full stop. Going full stop. Mr. S.K. Hazarika, the learned counsel, has also confirmed that the patta will be, if all the documents are found to be correct after the verification, the patta will be issued to the petitioner. Correct?
Verified.
Issued to the verification is done.
Yes, Lordship. Verification done, premium paid, revenue records were also. corrected.
Verification is done.
Yes.
Okay, Mr. Hazarika submits that verification of the documents have already been carried out and the patta will be issued to him, issued to the petitioner in a short time. He submits that since the grievance of the petitioner has already been met, there is nothing remains in the matter and the matter can be disposed of with a direction. I mean, how much time you will take?
3 weeks.
With a direction to the concerned authority to issue the patta within a specified time, full stop. Taking into account the submissions, this court is of the considered opinion that this matter can be disposed of with a direction to issue the necessary patta to the petitioner within a period of 3 weeks from receipt of a copy of the instant order, full stop.
Respondent number.
The petitioner is directed to submit a copy of the instant order to the concerned authority, that is respondent number 3.
Lordship.
Respondent number 3 at the earliest, so that the needful can be carried out by the respondent number 3. In terms of the aforesaid, the instant writ petition is disposed of. That will do.
Lordship.
Yes.
If they do not provide Lordship, then.
Then you'll have to come back again.
Lordship, oblige.
The other one you need some time.
Yes.
Okay, I heard MS Chaudhary, the learned senior counsel, assisted by so and so for the petitioner. Also heard Mr. S.K. Hazarika. You write that, huh? And G. Hazarika also. Then is MS Chaudhary prays for 2 weeks time to file affidavit in reply in the instant case. Let the matter be listed after 2 weeks. এইটো আগৰ কেছটো ফিল হৈছিল দুটা আছিল ন যোনটো ডিসপোজ অফ হৈছে তাত থাকে yes
Wait, please, Your Lordship. On the earlier occasion, Your Lordship has directed to produce the documents, if any, wherein a certain procedure was carried out
Mm,
in promoting the persons, even if they rank below in the gradation list.
mm,
I could lay down my hands in 2017 and 2021,
Mm.
wherein the same process was done. And accordingly, I filed an additional affidavit to bring it on record.
mhm.
That is also on record, Your Lordship. If I may draw Your Lordship's kind attention to page 359 of the additional affidavit.
359
Yes, Your Lordship.
Mm.
The operative portion is at page 361.
So your case was that like you were not in, you were not, though you were eligible, you were not in the zone of consideration
We have been-
because your ranking was lower because of your different qualification.
Yes, Your Lordship.
Mm.
I'd like to place slightly differently, Your
Mm.
Lordship. Even though they say that we rank below in the gradation list,
Mm.
the departmental promotion committee has sought for our ACS and everything,
Mm.
and they have considered us.
Mm.
It is not a case that they have not been considered us. The departmental promotion committee has considered us and recommended.
Mm.
But thereafter, the director, all of a sudden, in total violation of the recommendation of the DPC, has taken a stand on himself, which he could not. That's my precise case, one line of argument. So, and the second line of argument is that the qualification differs, which Your Lordship is satisfied on that ground. So when the qualification demands a BSc has to occupy a post and it has to be manned by a person having post basic BSc or BSc, you cannot bring in. So therefore, to nullify that issue, the persons, even if they rank below, they are considered for. That's what precisely was done in 2021.
That
and
is that is your additional affidavit.
Yes, Your Lordship.
Mm.
It's precisely that was done, and this time also it was done in
So
that
you
way,
are saying that there are a lot of vacancies,
Lordship.
vacancies for BSc qualified
Yes,
nurses,
yes,
BSc qualified nurses, but only because their position was put in the lower,
Right, Your
they were lower in the gradation list.
Yes, Your Lordship.
Those posts are still vacant and they have not been considered.
Right, Your
Only
Lordship.
one or two has been considered
Right,
probably.
Your 2%.
One or two persons have been considered.
Correct, Your
And others were not considered.
Correct, Your
And their stand is that because you were not there in the zone of consideration, you are not being promoted. Because it's the same gradation, that is their stand. It's the same gradation list, and Honorable High Court has hold that there should be one gradation list. There cannot be two gradation lists
Right, Your
for these two categories of people. So since there is a one gradation list, you are lower in the lower in the gradation this thing list.
Yes, Your Lordship.
Therefore, your case was not considered.
No, my case was
No,
considered.
your case was considered, but you
and recommended.
you're recommended, but the director has come to a conclusion that because since there is a one list and your rank is lower in the list, gradation list, you cannot be promoted. That is the case.
Right.
Correct?
Yes, Your Lordship.
And yes.
In 2021 also, Your Lordship.
So now this court inquired whether there is any instances wherein if somebody is lower in the rank also in the list, gradation list, whether his or her case has been considered or not.
Correct.
Since there is a vacancy.
Correct, Your
Correct?
Lordship.
That is, so you are bringing in certain documents saying that in earlier occasions,
Yes, sir.
similar cases have been considered
Correct. Your
and they have been promoted, though they were in the lower in the
Yes, Your
ranking list.
Lordship. Yes, Your Lordship. Your Lordship will, I'm obliged, Your Lordship has got it, Your Lordship.
Mm.
Now, if Your Lordships kindly turn to page 293. That is annexure A4 of the additional affidavit.
Page
93.
3.
Annexure A4 of the additional affidavit.
Yes.
Now, Your Lordship, this is the final common gradation list of the staff nurse of different health institution of the state of Assam for the year 2021-22.
Mm.
Now, Your Lordship will come to the minutes of the DPC that starts at page 359. That's the type copy. Your Lordship will kindly come to page 361.
Hmm. 361, yes.
Your lordship will start from the, after number 5, the second paragraph.
Hmm.
Initiating the meeting, has your lordship got it?
Hmm.
Initiating the meeting, the Director of Health Services Assam highlighted the purpose of the meeting and stated that it is imperative to fill up all the existing vacant posts, newly created posts of ward sister, ward in charge, sister tutor and PHN by promotion from the lower cadre of the post of staff nurse for smooth functioning of the health institution, medical college as well as government A&M, JNM training school,
Hmm.
centers in the state.
Hmm.
Srimati such and such, Joint Director of Health Services Nursing, briefed the place and details the promotion avenues along with the particulars pertaining to the sanctioned post. Present staff strength and vacancies of the ward sister, ward in charge, sister tutor, and PHN of different health institutions, including medical colleges before the promotion committee. They are as follows. Now, serial number 2 is sister tutor, your lordship got it?
Hmm.
The present staff is 45.
Hmm.
She reiterated that the zone of consideration for award of promotion is taken 1:4.
Hmm.
In this regard, the zone of consideration are prepared with strength of 1040 for 260 numbers of vacant post of ward sister and ward in charge. Your lordship will kindly look in the first column, that is 296 is the present staff, and the vacancy position of the ward in charge and ward sister is 200. That is extreme right of the column. 241 minus 41 is equal to 200. So for 200 posts, they have considered the zone of consideration are prepared with a strength of 1040 for 260 numbers of vacant post of ward sister, ward in charge, sister tutor, PHN, out of which the total prepared staff strength is 2156. Accordingly, in the same line, the gradation list is prepared as per the applicable mode of 100-point roster. Now, your lordship will come to page 362.
Yes.
I'll skip number 1. I'll start from number 2. The promotion committee decided to prepare 2 zone of consideration at the rate of 1:4 ratios from the common gradation list of staff nurse for preparation for promotion, considering the clinical and academic side of the incumbents. In this regard, for award of promotion to the post of ward sister, ward in charge in clinical side, the incumbent must possess a GNM diploma, BSc nursing, post basic BSc nursing, etc. And for award of promotion to the post of sister tutor, this is important, / PHN in the academic side, GNM training school, the incumbent must possesses BSc nursing, post basic BSc nursing. The promotion committee observed that in the prepared list of the first zone of consideration with strength of 1040 for 260 numbers of vacant post of ward sister, ward in charge, sister tutor, PHN, only one eligible candidate was found to be suitable for promotion to the post of sister tutor, PHN. Therefore, the promotion committee unanimously decided to extend the zone of consideration from the common gradation list up to the numbers of 236 only, with the requisite qualification for filling a 59 post numbers of vacant posts of sister tutor, PHN. And accordingly, promotions were awarded. That is at page 370, your lordship.
Page 3670.
Yes, your lordship. That is 14 December 2020.
So at that point of time also similar situation occurred.
Similar situation.
Situation occurred and they took into consideration the
Yes,
vacancy
your lordship.
position and they have widened the zone of consideration.
Yes, that is enlarging the
And,
zone of consideration.
Correct, widening or
Yes.
probably have a better word. So you're saying
sorry.
enlarging.
Sorry,
So, so they have, given the promotion letter.
Right, your lordship. In fact, your lordship, in 2017 also the same thing was done.
2017.
17 also the same thing was done.
But this time they have not done so.
That, your lordship.
So was there any reason for doing so?
No, this time also it was done.
Hmm.
It was the unanimous decision of the DPC to do so. May I take your lordship's kind attention to the DPC once again?
Yes. Because we heard it long time back, so
Yes, your lordship.
we'll have to point out the certain things.
187
Page 187.
of the writ petition, your lordship.
So we'll come back in 5 minutes.
Yes, your lordship.
Just for 5 minutes. A space you said,
Page 187A of the writ petition.
187.
Yes, Your Lordship.
Yes,
The Lordship will come to the next page at page 187.
187A.
Yes, Your Lordship.
Yes.
Serial number 3.
Rule number 3.
Yes. The Departmental Promotion Committee unanimously suggested to DHS Assam to fill up the vacant post of such and such by way of promotion. The various posts are mentioned. Now, number 4. The Departmental Promotion Committee decided to award promotion in two ways process for the post of ward sister, ward in charge, nursing sister, OT sister, PHN, that is clinical side, and academic side from the seniority list of the staff nurse published on 2011-2004. In the clinical side, for the post of ward sister, ward in charge, nursing sister, OT sister may be filled up from the post of staff nurse having JNM diploma holders, and in the academic side, for the post of sister tutor PHN may be filled up from the post of staff nurse having BSc nursing, respectively in order of seniority come merit. So the same thing, it is a recital of the same thing which took place in 2021 and 2017, Your Lordship. Your Lordship, let us try to understand the intent and the object of the DPC as well as the DHS. For that, Your Lordship will have to come to page 186 once again, Your Lordship. The intent was very clear: to promote the petitioners to the cadre of sister tutor, knowing very well that those posts can be filled up only by the BSc nurses. And therefore, this letter was shoot up, Your Lordship.
Page
186.
Yes.
With reference to the subject cited above, I have the honor to inform you that this Director of Health Services Assam is going to promote the staff nurse to the post of ward sister, ward in charge, nursing sister, OT sister, sister tutor, PHN, or its equivalent post who are working in different health institution under Government of Assam. Therefore, you are hereby requested kindly to furnish the vacancy position of the aforementioned post within 7 days along with the 5 years ACS of the staff nurses who have joined in services on or before 2011. I'll pause there for a moment. Admittedly, you have not been appointed in 2011.
Hmm?
Admittedly, we have not been appointed in the year 2011. We have been appointed in the year 2018. And the rule says 5 years of service in the feeder cadre. Only then you can be considered for promotion. Now the next para. You are requested to furnish
On or before 2011.
11,
Hmm. So you have appointed on 2018.
18, 17, 18, thereafter.
So by saying so, what they have done?
They mean to say that 2011 will mean to fill up all those vacant posts of ward in charge and sister of ward in charge
Hmm.
who are GNM, not the BSc nurses. They are seeking only for prior to 2011 and 2011.
So you are out.
I am out. Now the next para. You are also requested to furnish last 5 years ACR of the staff nurses having MSc, BSc, post basic degree who have joined the government service on or before the year 2018. The registration certificate for additional qualification along with NOC who have completed the post basic BSc nursing courses should be submitted. So why this para was added? So the object and intent was to fill up the vacant post of sister tutor from the cadre of the BSc nurses who are even below this rank of below in the gradation list. They are aware of the fact.
And they asked for on or before 2018, and you are appointed on?
We are appointed in 2017, 18.
So prior to this 2018.
Yes, Your Lordship.
Hmm.
So therefore, their intention was clear. The object was very categorical that they want to fill up the post of the sister tutor from all those staff nurses who are BSc in graduates, who are BSc and who have been appointed on or before in the year 2018. So what was the purpose otherwise to add this?
But only problem is they are facing is that there is a single list of gradation.
Exactly, Your Lordship. This was also, they were aware. that single gradation list is there. They were also aware in the year 2021. They were also aware in the year 2017. Otherwise, who will man those posts? Your Lordship will kindly appreciate one fact of the things. The zone of consideration has to be filled up by the persons who are eligible. It cannot be from the persons who are not eligible. So therefore, the post to fill up the cadre of sister tutor, all those persons who are eligible first has to be considered, and then you have to pull them into the zone of consideration. That exactly what the 2021 DPC said. And in fact, 2024 DPC, wherein we have been recommended, that also says the same things. And it's a past practice that has been followed. Therefore, they are widening this. Otherwise, this entire exercise is a futile. And if we are not promoted, we will be the first batch not to being promoted even after being considered. We are much more educated.
But
than
in
them.
2021 also same single list was there,
Yes,
single gradation list,
yes,
17
yes.
was a single gradation
Yes,
list.
Your Lordship.
But 17 and 21, they have widened the zone of consideration,
Yes, Your Lordship.
enlarged it, and like
Yes.
accordingly, they have promoted
Correct, Your Lordship.
from the.
Yes, Your Lordship. I have annexed everything on record.
Okay. So this is your case.
Yes, Your Lordship. And I'll just like to place three judgments, few judgments on eligibility and a few judgment on the past practice, if Your Lordship kindly permits me.
Yes, which whereas?
Your Lordship will turn to page 587. Down below, Your Lordship has got it the 11th line from
No,
below.
which paragraph?
Para 5. 11th line from below, Your Lordship.
Suresh Nathan,
Yes, Your Lordship.
11 line from
Down, Your Lordship.
down below.
The only question before us is of the construction.
Hmm.
The only question before us is of the construction of the provision and not of the meaning of the provision. In our opinion, the contention of the appellant degree holders that the rules must be construed to mean that the 3 years service period in the grade of degree holders for the purpose of Rule 11 is 3 years from the date of obtaining the degree is quite tenable and comments to us being in conformity with the past practice followed consistently. It has also been understood by all concerned that till the raising of this present controversy recently by the respondent, the tribunal was therefore not justified in taking a contrary view and unsettling the settled practice in the department. So therefore, Your Lordship, if there is a practice that has been going on, which is not tinkering with anything, and that is being followed by all concerned, in fact, by the DPC, they cannot unsettle that practice, Your Lordship. Your Lordship, the second judgment I would like to place is that on the legitimate expectation and the vested rights, the petitioner has acquired a vested rights and has a legitimate expectations to be promoted to the cadre of
So
sister
in,
tutor.
in service law, this legitimate expectations will be there. That principle can be applied to service law.
Your Lordship, I would just like to touch the principle on the with parametria to vested interest, vested rights, Your Lordship. Page 148, Your Lordship. Internal page.
You give me para.
Para 26. The last few lines of this para, that is page 148.
Hmm.
Last fourth line, Your Lordship.
Hmm.
An expectation could be based on an express promise or representation or by established past action or settled conduct. The representation must be clear and unambiguous. It could be a representation to the individual or generally to a class of persons, Your Lordship. Here is a case, Your Lordship. You have consistently followed that practice and have been abiding by that. in the larger public interest. Otherwise, who will train those nurses in the GNM training schools, Your Lordship? There are many medical colleges coming. So if we don't have sufficient numbers of nurses to man those hospitals, it will be a chaotic situation. That's the larger public interest. So we have to go to those schools to teach those students. There is no denying the fact that anybody else can teach it and we cannot teach. Anybody else other than us can teach those students.
Yes.
Last one judgment, Your Lordship is aware of that judgment, Shailendra Dania. I'll straightway come to para 36. Page 554.
Yes.
From a reading of the decision rendered by this court, one thing is clear to us: a decision in such and such are based on the interpretation of the respective rules called in question, giving meaning to the word used in the context of the entire scheme governing service conditions and the facts involved in each case. And it can be said the decision rendered by this court after the decision of Suresh Nathan's case have taken a different view and what has been decided by N. Suresh Nathan's case. Thus, we are required to decide the matter on the basis of the entire scheme of the rules, the facts and the circumstances at the relevant time, and the rules called in question before us, independently giving meaning to the words. The principle involved in the past practice, if any, which is in consonance with the interpretation given to us to the rule. If you find two ways are possible after interpreting the rule, then the rule would be interpreted keeping with the practice followed by the department for a long time. And thus the practice practically acquired the status of rule in the department. So this practice will acquire the rule of the department, Your Lordship. It is the call of the hour. You cannot approbate and reprobate at the same time, Your Lordship. And it is only one man who is standing in the way of our promotion. That is the director. He could have well objected before the departmental promotion committee. He could have said, no, we cannot do it. They can't be done. He has agreed to that and he has then taken a U-turn.
So what is the power of the director?
He is the appointing and the promoting authority. He is the person who, he is the cadre controlling authority, Your Lordship. But the departmental promotion committee has taken a call. You were a part of that committee. Now, can you go back and say, no, it cannot be done? When I have clearly demonstrated before Your Lordship that this has been the practice followed since 2017, or maybe earlier to that.
Okay.
And Your Lordship, one issue I would like to address, the GNM syllabus to the assumed.
The copy of the rules you have given over?
Yes, Your Lordship, I have given. If required, I can give one more.
No, we'll see.
Your Lordship, this is the GNM syllabus.
Hmm.
I just want to point out one thing in the internal page 9. The page numbers are given below. Page number below.
Yes.
If Your Lordships come to this, the teaching faculty, has Your Lordship got it? Page 9.
Page 9, yes.
Teaching faculty at the top, it's written.
Huh.
Then Your Lordship will come down. Qualification of the teaching staff. Principal, MSc nursing with 6 years of teaching experience or BSc nursing experience. Then the next page, your lordship, vice principal is also MSc, senior tutor is also MSc. Then comes the tutor, MSc in nursing or BSc in nursing. So the GNM curriculum specifically says that the tutor has to be BSc and MSc. How you overcome it? And therefore this past practice was developed and it caused no harm to anybody. It was not at the cost of the interest or it did not violated the article 14 or 16 of any other persons. Let us make it very clear.
So page 193, that is that mm, 193.
Yes, your lordship.
So this has been written by the Director of Health Services to the Commissioner.
Yes, your lordship.
So here it says that as per seniority list, so and so, so and so.
Yes, your lordship.
Now says only 2 numbers of candidates
Correct, your
Ah.
lordship.
are found eligible for promotion post of so and so. Remaining 81 numbers of so and so could not be filled up due to new non-available. This is the letter you are impugning, right? Kind of non-availability of candidates with requisite qualification under zone of consideration as per seniority. So total 81 numbers of posts of sister tutors are not yet filled up.
Yes, your lordship.
But there is essentiality
Yes.
of the post to run GNM training school smoothly. So I request your perusal and advice for smooth functioning of the GNM training.
Correct, your lordship.
The seniority list so enclosed. So what has been done after this by the Commissioner and Secretary?
Your lordship, the commissioner and secretary, they have been corresponding with each others.
Mm.
Like I'll just.
No, is there any reply to this letter? Because see, director has specifically stated
Yes, your lordship.
that, but there is essentiality of the posts
Right, your lordship.
to run GNM training school smoothly.
Yes, your lordship.
So what is their action taken?
Your lordship.
What is the action taken by them?
I'm just coming to that, your lordship. There is a reply, your lordship, at page 13.
Hmm?
Sorry, page 223.
Two 23.
Yes, your lordship, annexure 13.
Hmm.
With reference to your letter dated 11/6/2025 regarding the proposal for approval of government to consider INC norms for promotion of nursing personnel in the academic side, I am directed to convey the approval of the government in this regard. As per your request, you are allowed to follow the INC norms for promotion of the nursing personnel in the academic side. Therefore, in view of the above, we are hereby requested to ensure that INC norms are strictly adhered to the promotion process and the decision of the promotion committee are implemented accordingly. So there is a categorical direction that please follow the direction of the departmental promotion committee. And your lordship will appreciate one fact of the things. There is a recommendation by the DPC. You accept one part, you don't accept the other part. Neither there is any finding from your part that will not accept that. Which you cannot, in fact. It has to be accepted in toto. Whatever suits you accept, whatever does not suit you don't accept. And this is totally U-turn. Definitely it's a malified interest, your lordship. It cannot be in the interest of the public. Otherwise, there will be chaotic conditions.
Anything else?
Your lordship, I have given few judgments on the last occasions, your lordship,
Those are there.
on as regards the eligibility, your lordship. That is
There is no
1980
doubt about your eligibility. There is no doubt about your, that you have been appointed, duly appointed on a particular date as per the eligibility criteria,
here-
2018.
Here, I would.
You have shown me that, what are the qualifications required for that
Your lordship.
BSc syllabus you have shown me. So only thing is that like there is a one, as per the direction of this honorable court division bench, a single list.
Yes.
Now single list they'll have to prepare. The only thing that while preparing the single list, they are facing some difficulties. Facing some difficulties is that the petitioners are below the, below in the select list, gradation list. Now, because of that, they are not coming in the zone of consideration and they could not be promoted. Now, the thing is that there are many vacancies are there, 81 vacancies are there
Correct.
still. And without the 81 vacancies being filled up, how they are going to run these institutes? That has to be answered by him, because 81 vacancies are there. And past practice is that like they usually take people from the below, because in the top there is nobody who has the qualification. Sufficient numbers of qualified people are not there. Only 2 people are there. So in that connection, what they have done, they'll have to tell us.
Your lordship, I'll just like to place one thing in this way.
Mm.
It is not a case that we have not been considered or not brought in the zone of consideration. Rather, I would say that our rights have accrued since 11/11/2024, when the letter was shoot up by the DHS to all concerned where we have been working, to all the health institution. And secondly, it has been crystallized by way of
Now,
the
what is the
DPC.
ratio they have given?
1:4, your
Mm.
lordship.
So 1:4, you are not coming.
No, that's what I'm saying.
Mm.
Now, our rights got crystallized in the minutes of the DPC,
Mm.
wherein they have categorically stated you do it. So meaning thereby the zone
So
of
you
consideration.
what you basically want to say is, since they have called all the ACS, your
Mhm.
thing has been considered. So that ratio 1:4 will not be there. Is it so?
No, what
Then-
I'm trying to say is
But
that
1:4, if it is followed, then you are not there.
your lordship will see, once again, if I may draw your lordship's kind attention
Mm.
to the additional affidavit wherein I have annexed
Mm.
the
Mm.
minutes at page 361.
Mm. So they have taken a conscious decision there.
Yes, your lordship, to prepare 2 zone of consideration. Of course, 2
Correct.
zone of
No,
consideration.
I'm talking about the instant case.
Yes.
Instant case, they have rejected you only because that you were not there in the zone of consideration.
Your lordship, they have rejected means it is the only call of the director, not the DPC, your
That's
lordship.
what I'm saying. Whoever,
Which they
that
cannot.
that aspect will see whether director has the power or not. Whether director has the power or not. What is your argument on that?
Your lordship.
You
on
say that the DPC is the committee who has recommended it.
Yes, your
Now,
lordship.
whether director can, reject your candidature or not, that has to be seen.
Your lordship, to that extent, I have placed one judgment on the last occasion, 2007-14 SCC 641.
Hmm.
I'll just read that para, 27.
What is the name of the case?
Your Lordship, the name of the case is Union of India and another versus S.K. Goel and others.
Para
27.
27. You have placed another case, R. Prabhadevi.
Yes, Your Lordship.
Can you give me the paragraph? Last time probably something, I mean, I missed out or you didn't give me the paragraph. I don't
I'm sorry, Your
remember.
Lordship.
I don't remember. I don't remember. You may have given, what is the paragraph?
Para
Can you give me?
15, Your Lordship.
Para 15.
Yes, sir. That is with regard to eligibility.
Correct. Para 15, na?
Yes, Your Lordship.
Okay. So para 27, let's say.
Yes, Your Lordship.
Hmm.
Has Your Lordship got it?
Yes.
In our opinion, the judgment of the tribunal does not call for any interference inasmuch as it is followed the well-settled dictum of the service jurisprudence that there will ordinarily be no interference by the court of law in the proceedings and recommendation of DPC unless such DPC meetings are held illegally or in gross violation of the rules or there is misgrading of the confidential report. Your Lordship, the Supreme Court has said that even the courts cannot tinker with the recommendation of the DPC. How can the director do that, Your Lordship? How can he take that independent decision? And that too on his own.
Yes.
Your Lordship, I'll just read few lines from Prabhadevi as Your Lordship has referred to para 15.
Yes. Prescribing.
Last,
Prescribing of an eligibility condition.
yes, Your Lordship. The prescribing of an eligibility condition for entitlement for consideration of promotion is within the competence of the rulemaking authority. The eligibility condition has to be fulfilled by the section officers, including senior direct recruits, in order to be eligible for being considered for promotion. When qualifications for appointment to a post in a particular cadre are prescribed, the same has to be satisfied before a person can be considered for appointment. Seniority in a particular cadre does not entitle a public servant for promotion to a higher post unless he fulfills the eligibility conditions prescribed by the relevant rules. A person must be eligible for promotion having regard to the qualification prescribed for the post before he can be considered for promotion. Seniority will be relevant only amongst person eligible. Seniority cannot be substitute for eligibility, nor it can override in the matter of promotion to the next higher cadre. Now, what is the underlying principle of this judgment? It says that I have to be eligible before being considered. Now, this all theories they are bringing not in the zone of consideration. We cannot promote them. We'll run by this and that. We'll not hold the field because admitted fact is that we are eligible and therefore we have to be considered and brought into the zone of consideration. And therefore the past practice was done by widening the zone of consideration.
Right.
Now, Your Lordship, the rule says suitability.
Now, those, I mean, I don't think they are disputing about your eligibility or whatever. Their only thing is the single reason list.
Therefore, they will widen the, therefore, not they, in fact, that has been done by the DPC.
That, I mean, now you're saying that like, because that is a tradition they have been following.
And past practice has to be followed. If there is nothing in the rule, that has become the thumb rule of these 1991 service rules. Your Lordship, I'll conclude my submission with that. Subject to,
You conclude and let us hear him.
if there is something to reply, I'll reply. I'll come back. Your Lordship.
Yes.
I'm deeply obliged.
Yes, Mr. Bora.
Yeah, praise the Lord.
Mm.
My lord, the first issue regarding the minutes, my lord, that the minutes of 16/12/2024, there was a recommendation.
Hmm.
Assuming that, my lord, recommendation, because otherwise, my lord, DPC can only recommend.
Hmm.
The ultimate authority to take the decision is the appointing authority. So recommendation only the DPC can make, my lord, and that is not mandatory on the appointing authority, my lord. Otherwise also, my lord, the minutes dated 16/12/2024, if we compare these minutes with the earlier minutes of the 2021, in the year 2021, the zone of consideration was specifically extended, my lord.
No, extended for similar circumstances.
Similar
There,
circumstances.
that time also, because there were vacancies, then
Yes,
without.
that time there was vacancy, it was extended, but this time, my lord, it has not been extended.
It has not been extended. That's why you have not extended it. How you are going to mend those people?
Because, my lord, on earlier occasion,
Mm.
other case, my lord,
Mm.
on last date, my lord, I produced a copy of that order, WPC number 3069 of 2018, my lord,
1 second.
wherein this honorable court has been pleased to hold that, my lord, there cannot be two gradation lists, my lord.
What's the name?
Or I can give you 3069 2018, please. 3069 2018, order dated 16/11/2020.
No, it is not there with me.
So I am furnishing one copy, my lord. Here is also the case was that, my lord, they prepared two gradation lists, my lord. So as per rule.
No, that is understood. I mean, they prepared
Yes, my
two
lord, there
gradation
cannot
lists.
be two zone of consideration on clinical side or academic side, my lord.
Now tell me how you are going to mend those people.
My lord, that is up to the administrative.
No, administratively, you'll have to answer the court. You'll have to answer the court how you are going to manage it. You have
My lord,
been,
that is not
you
the
have,
concern
no, no,
of the
please,
petitioner, my lord.
please. You have been written, yeah, you have written to those people, right? We'll have to see all these things.
Yes, my lord.
You have written to the secretary, commissioner, or whatever.
Yes, my lord.
I mean, after that, what steps you have taken? Have you, no, if you say that like we have taken these steps to mend those people,
My lord,
then
regarding
that is one of the factor. I mean, which.
Because telephonically, I asked them, they have been saying that, my lord, some persons have been engaged there on in-charge basis, my lord.
Hmm. Who are those people?
Probably.
See, 81 vacancies, Mr. Bora, 81
Yes, my lord,
vacancies.
there
It's
are
a,
more than
it's,
thousands of.
it's a huge vacancy. So how you are going to mend them? So you have eligible people, right?
Yes, my lord.
You have eligible people.
But
Only,
we ca-
only thing is
because
that,
we
no,
don't
listen
have
to
the
us,
people.
listen to us.
Yes, my lord.
Only thing is that they are lower in the rank, but
Yes.
otherwise they are eligible.
Yes.
And without giving them any promotion, only because this it's a gradation list, and you are saying that they are not coming within the zone of
As
consideration.
per rule,
Yeah, zone of consideration as per rule.
we are
Uh,
acting as per rules.
You show me the rule where it says 1:4.
It is the,
No, show me the rule. Don't argue and submit this thing. You show me the rule. Have you carried the rule?
no, my lord.
Then why you are not carrying the rule? You are coming to argue this matter. Why are you not carrying the rule? How will you show it to the court now? You are saying that 1:4 is the the rule. That is the prescribed rule. So where is the rule? You show me. You show me. You show to the court. Where is the rule? The zone of consideration is to be 1:4. Court doesn't know from which rule you are saying. You show me. I mean, if it is there, it's fine. You show me where is the rule which says 1:4 has to be mandatorily followed. Mr. Singha, any rule there?
Yes, sir.
Where?
May I just produce it?
Now this rule is there. Which paragraph are you telling me that? Which rule is this?
This is the Assam Nursing Service.
Correct, I mean, particular specific rule. Gradation list,
Attachment to the disclosure.
22. Or what?
11.
এইমাত্ৰ যে মানে এটা যে দিছিলোঁ আপোনাক মেইল কৰিছিলোঁ মানে 306
Hey, give him a copy now, Mr. Singha.
Yes,
If you
yes.
have a copy, give him to Mr. Bora also.
It's pointed.
Probably the 1:4 is not here in this rule, my lord. That is from the service rule, my lord.
So where is that? That's what I want to understand. See, this is Assam Nursing Service Rules.
Yes, my lord.
Yeah, 1991. Is there any amendment after this?
No, my lord.
Then
That amendment is under process, my lord.
there is one amendment probably 1991, 98.
Yes, my lord.
98 says,
Your lordship will kindly come to page 43 of this rules,
43.
the one which I've given it. It is
43 is not there. I mean,
11, I'm sorry, your lordship.
that has been cut down. I mean, that marking,
Uh,
39.
Yes, your lordship, 11. Okay, 11:3, 12:2, your lordship.
The general procedure.
Yes, your lordship.
Correct. That's it. That is the one.
Before the end of each year,
Hmm.
has your lordship got it?
Hmm.
Before the end of each year, the appointing authority shall make an assessment of likely numbers of vacancies to be filled up by promotion
Hmm.
in the next year to each cadre.
Hmm.
The appointing authority shall then furnish to the board the following documents of information with regard to the officers equal to 4 times the number of vacancies in order of seniority eligible for promotion. Your lordship, I'll just like to pause for a moment. It says that you have to recommend 4 times the number. It does not say that when the promotion committee takes, it cannot take more than that. Yeah, 12. Two. It says that they shall, it is minimum number of persons they have to recommend. It is not said that for every one post, 4 persons have to be considered. So there is no harm if more number of persons are considered.
Zero 2018. ওলাব নহয় 3069 2018. Order dated 2011-2020. 16/11/2020.
So this case was, this has gone to the division bench.
Yes, my lord.
This has gone, this was challenged in the division bench.
Yes, it has been.
And division
upheld.
benches affirmed this,
Yes, my
right?
lord. Yes, my lord.
Now see, Mr. Bora, his case is that earlier also similar occasion happened.
Yes, my lord.
So earlier same incident or same kind of incident occurred, and
Yes,
2021 and 2017, they have a department has taken a call. The department has taken a call, and in that case, in fact, the DPC has in their minutes has taken taken into account that specific incident of vacancies and all, because it's the same list. Hmm?
DPC says, my lord,
Hmm.
that as per INC guidelines,
Hmm.
for the promotion to the post of tutor, my lord, the INC guidelines norms should be followed.
Followed.
And BSc nurses with BSc should be considered.
Hmm.
And for
No,
the-
correct. No, I'm talking about the other two occasions, 21
Yes,
and
madam.
20.
And accordingly, that time the
Hmm.
zone of consideration was extended
Correct.
specifically.
Correct.
Yes, madam.
So I mean, that time also INC guideline was there. INC, this rule was there.
My lord, I cannot say that, my lord, but now the thing is that.
No, this is 2021. Obviously,
my
this rule was there.
Yes, my lord.
This rule was not redundant.
What I am saying, my lord,
Mm,
each time, my lord, whatever the department is doing, the director is doing, he is doing
Mm.
as per the rules.
How he is doing as per the rules? Now see, this court is asking because he has argued.
Yes.
So you'll have to reply to those.
Yes, my lord.
So now DPC is one of the committee which has been which consists of experts, right?
Yes, my lord.
Consists of experts, and it has been formed specifically to scrutinize the papers
Yes,
and the ACRs, whatever,
Yes.
for the candidates, and prepare a list.
yes, my lord.
Correct, taking
Yes.
into account and recommend people.
Yes, my lord.
And recommend people. Now, once DPC has recommended,
What
His
DPC
case-
has recommended?
correct,
Kindly see
let
your
us see
page.
that. Please show
Yes,
me
my
that.
lord. Page 188, my lord.
Correct, 188.
Clause 4, my lord.
188.
Yes, my lord. Clause 4, my lord.
Page 188, that vacancy position, different career, that page.
Yes, my lord. That is the DPC starts at page 187.
Correct.
My lord.
So this is a continuation page.
Yes, my lord.
Page,
188, clause 4, my lord.
one
The
second,
relevant
one
clause.
second, page 188. Clause 4.
The Departmental Promotion Committee
Hmm.
decided to award promotion
Hmm.
in two ways.
Hmm.
Process for the post of ward sister, ward in-charge, nursing sister, OT sister, PSN.
Hmm.
That is clinical side.
Hmm.
And academic side from the seniority list of staff nurse published on 2011-2024. In the clinical side for the post of ward sister, ward in-charge, nursing sister, OT sister may be filled up from the post of staff nurses having GNM diploma holder. And in the academic side for the post of sister tutor, PSN may be filled up from the post of staff nurses having BSc nursing, so and so, so and so. So it has been followed, my lord. So the candidate nurses who have been found within the zone of consideration, this particular recommendation has been followed, my lord. Because
that is the other difficulty is that, like,
yes, my lord, I understand, my lord. The
difficulty-
difficulty even with the director also.
No, difficulty is that, see, how you are going to create a zone of consideration,
Yes,
right?
my lord.
Now your rule says,
Yes.
if the vacancy is 2, then as per the rule, you'll have to send 8 people
8.
for zone of consideration.
Yes.
Now your vacancy for this post is 81, not 81, 83.
Yes.
So how many you have sent?
No, my lord. It is cadre wise, my lord, not
No,
particular. post wise.
Understood.
Now
No-
problem is that
Mm.
some problems are there with the rules itself,
Mm.
and that's why, my lord, as of today, my lord, there is a process for amending the rules.
Mm.
So in the amendment, it has been proposed
Mm.
for clinical side, for academic side.
Mm.
So there will be specific provision for, my lord, this thing, my lord. This will be addressed, but with the present rule, my lord, this difficulty is continuing, my lord. And one more aspect, my lord, I would like to submit before your lordship.
Mm.
If your lordship comes to clause 9, page at 189,
Clause 9.
clause 9 of this minutes, my lord.
Yes.
Page 1, as your lordship is saying that the practice which is being followed, my lord,
Okay, for the post of,
for the post of existing vacant post of PSN under DSS FW Assam,
mm,
30% of posts shall be filled up by way of promotion from the cadre of staff nurses
mm,
having BSc nursing, post-basic BSc nursing who are under DSS
Mm.
and DME Assam.
Mm.
And the remaining 70% posts shall be filled up from the cadre of LHP who have completed PSN diploma course under DSS FW Assam. Accordingly, DSS Assam so-and-so share the details of seniority gradation so-and-so. So, my lord, in the same year, in the month of November, another DPC was held under the chairmanship of the DSS FW, wherein by following the past practice, my lord, they intended to promote this 70% PSN. The petitioner, one petitioner here, my lord, she challenged that the particular promotion process, and that has been stayed, my lord. That process, past practice that was being followed in that case. Your lordship may kindly peruse this order, my lord. That
Yes.
Rinti Boisho, my lord, Rinti Boisho and some others, they preferred the another writ petition by challenging that promotional committee, my lord. And they are also, my lord, the promotion to the PSN post are being held up, my lord. If they are concerned with fulfillment of the post of PSN, my lord, why they have sought for stay of the proceeding, my lord?
No, here it says, it says for the post of existing vacant of PHN cadre, PHN under DHS.
Yes.
So is this different? Is the same thing?
Ultimately, they will be placed in the school, my lord, but PSN under DSS or FW and PSS under DSS.
Mm.
So,
in this case, who are the people? The people are with the same
yes,
PHN under DHS.
yes.
So here also in under.
May I just clarify
Mm,
this
mm,
part? Your
mm.
lordship? I would like to come to this.
Mm.
Herein, it is said that if your lordship correctly remembers, there is another case which says that A&M nurses
Mm.
who are promoted to LHV.
Mm.
Here, this is a DPC which took place somewhere in 2025, which says that 70% of the PHN posts will be given to the A&M
Mm.
and only 30% will remain for the BSc graduate nurses. So that 70% which will be given to the A&M, that was put to challenge, saying that they are not eligible for this post. And therefore the court has stated, and that was done by the association, wherein
My lord-
Rinti Vaishyo, who is one of the petitioner here, is a general secretary of that association. So the
And-
association has put to challenge the impugned action on the part of the DPC in allotting 70% of the seat of PHN to the A&M nurses who are otherwise certificate course
And
holder.
then 70% post, my lord, doesn't include the post connected with the writ petition. That 70% post under the DSS FW. Now here the posts are under DSS, my lord, Director of Health Service.
So DHS is different, DHS FW is
Absolutely
different. Different.
DSS, Director of Health Service, Family Welfare.
Mm.
So that 70%, Because out of the 100% post of DSS FW, because ANM are the employees under the DSS FW, out of their 100% post, my lord, 30% were given to the DSS, my lord.
Director of Health Service Nurses.
Yes, my lord. And they are
And
also, my
70%
lord,
from there.
because their contention in that case is that, my lord, rule specifically does not allow the promotion for the ANM. But that was the process. There was a process followed by the department for last several years that ANM or LSB, they will undergo one particular training, 1 year diploma training, and after completing the diploma training, they will be eligible for the post of PSN. Accordingly, by following that process, they were being promoted. And they challenged that process, my lord. Now, if they won here by their promotion on the basis of the practice followed for last several years, in that case also they should not have challenged that, my lord. Because the practice which was being followed by the department for last several years, on that basis they have challenged there. And they are stated that it should be done as strictly as per rules, my lord. Why they are contradictory stand here, my lord? If it has to be done as per rules, it should be done strictly as per rules, my lord. And
Okay,
in
we'll
terms-
we'll resume at 2 o'clock.
My lord, may I submit one thing, my lord? Can it be taken up tomorrow or day? Because at 2 p.m. I have got a Padhar matter before the code number 10, my lord. It was fixed last week itself, my lord, at 2 p.m., my lord.
Wait, this bench will not be available after after
Any day,
Thursday.
any day convenient to your lordship, my lord.
After Thursday, then your lordship may fix it on Thursday. It will be from-
So we have only 2 days.
The
This
lordship may
week.
fix it tomorrow, no issue.
Tomorrow is a motion day, bola. It will be a lot of matter. I mean, there will be a long list. So we can keep it on Thursday.
Thursday,
Thursday is fine.
can it be at 2 if your lordship, if it's not inconvenient, your lordship?
Okay, because it's a part heard, we'll take it up before other matters.
Yes, my lord.
It will be part heard, so we'll take it up. I mean, you have some problem in first half.
First up, I have some problem. Let it be at 2, your lordship. I'll take hardly half an hour to reply, whatever time it takes.
Okay, matter heard Mr. R. Singha, the learned counsel appearing for the petitioner. Also heard Mr. B.P. Bora, the learned standing counsel for health department. No?
Yes, my lord.
It is DHS or DHS
Health
FW?
department. All the directorate are under the.
Under health department.
Yes, my lord.
That is very confusing. Health,
Because they are-
DHS, FW, DHS, then
Four
DME.
directorates are
My
there.
learned friend is
DSS,
trying to confuse it.
DSS, FW, DME, Director of Medical
Ah.
Education and Director of Ayush. 4 directorates are there.
So for director, so you are representing all
Yes,
all
ye-
4.
yes, my lord.
Okay. Bora for Director of Health Services. So it can be said DSH
Yes,
It
yes.
can be said
or Health Department.
Health Department.
Health Department will be better.
Yes, my lord.
Okay, Health Department. The matter remain part heard. Let the matter be listed on Thursday, that is on 30th. Let the matter be listed on 30th.
At 2 p.m., your lordship.
We'll accommodate.
Yes, my lord.
If the list is over before that,
Yes.
then what is to be done? Then you'll have to come rushing.
Sure.
We'll see, we'll accommodate. Okay. That have been, that cases that have been referred to in the instant case. Full stop. Mr. P. Bharadwaj, the learned counsel appearing for the respondent, has fairly submitted that the order impugned in the instant case cannot be sustained in view of the settled law, in view of the settled law decided by the Honorable Gauhati High Court as well as the Honorable Supreme Court. In view of the aforesaid, he submits that he would like to concede in the matter, and the prayer that has been sought for may be granted to the petitioner. Full stop. Taking into account the aforesaid submission of the learned counsel appearing for the respondent, this court does not feel necessary to go into details of the facts as well as merit of the case at this stage. I don't think I need to go into other details, right? I mean, whatever is there, I mean, I don't need to like go through, I mean, provisions and all these things. Since you are conceding it, we are allowing it. In details in the instant case. Full stop. In view of the aforesaid, the instant petition is allowed by quashing and setting aside the impugn order dated 23/12/2025, passed by the district judge, Gwalpara, Panchayat election tribunal, Gwalpara. Full stop. It is needless to say that the proceeding before the aforesaid tribunal in MISC in bracket election case number 09/2025 shall go ahead, and the matter shall be decided as per law. As per law.
2020.
Hmm?
01/2020.
The number I have given as per the law. In terms of the aforesaid direction, the instant writ petition is disposed of as allowed.
Interim order. There was the interim order.
Hmm? No, that we have set aside only that order. I mean, we have stated that needless to say that the proceedings will go on there, and it will be decided as per law.
It is referring to the interim order passed by the Sabha.
Automatically vacate.
It will automatically vacate, it's allowed.
Publish.
Oblige.
Well hearing.
This case also TCR was called for, that is not this,
He says come.
not received.
Okay. None appeared for the accused applicant when the matter was called for. Though Mr. P.S. Lockhart, the learned APP, is present. Mr. A. Misra, the learned counsel correspondent number 2, is also present. Since TCR in the instant case is yet to be received, registry to send a reminder for the TCR to the court of learned CGM Dhubri. Let the matter be listed.
It actually takes the matter on 25.
Then how it has been listed?
Not aware, because even as per the.
Then list the matter on 28/4/2026.
On 25.
Hmm?
25 2020.
No, earlier that it was, the last order, it says 28/4.
Now it may be for 13th of May or 14th of May.
No, I mean, this code will not be available. So it will go to 21st of May. I hope we have the TCR comes, because we cannot keep this matters pending also. Problem is that, but these banks will not be available for 2 weeks. That's why we'll have to.
Orders. Right, Mr. Bashir. This is regarding victim compensation matter. Victim compensation, my lord.
What?
The victim compensation. My lord, the page 45, the petition submitted by the petitioner.
But this has come for orders, Mr. Counsel. Orders, are you going to argue the matter? Have you seen why it has come for orders?
Regarding service of respondent.
Then you should submit that. Why are you arguing the matter?
Then, my lord, lodging a court order, my lord.
Then you should point out that, Mr. Counsel. Then without service of notice, should this court hear your matter?
Service is complete,
Hmm.
as per lodging a court order. 10-2.
Okay, heard Mr.
Camp Hussain.
So and so, and also for the petitioner, also heard J. Hendik for
As per the 1 and 2, Lordship.
for respondent number 1 and 2.
Lordship,
Uh,
in this matter,
Hmm.
the respondent number 3 to 5, their name had not been reflected in the list for this. So one copy I will do.
3 to 5.
Lordship. The state legal cell,
Asal sir.
Is anybody appearing for them?
Lordship, yes, ma'am. Also,
Is there any standing counsel for?
Lordship.
Standing counsel is there.
Number 3.
Hmm?
For respondent number 3,
For respondent number 3, standing counsel is there.
Lordship,
Asalsa.
Lordship.
Okay. As then you write, as per the Loajima court proceedings dated 10 to 10/2/2026, comma. The service is complete on respondent on respondent number 5. Full stop. Let the matter be listed for admission in usual course. The name of the standing counsel, the name of the standing counsel for respondent numbers 3 is directed to be shown in the cause list. Full stop. Let the matter be listed after 2 weeks, after 3 weeks.
If possible, date may be given.
Let them come. That will be difficult now. Let them come. 3 appear.
14 and 15 hearing.
Also, we were supposed to file a short affidavit. We have already filed affidavit, but some instruction thereafter came, and the honorable court directed us to place it by way of affidavit. That has been sent for vetting. When the matter may be fixed on any other day.
Okay. Mr. B.J. Talukdar, Lalan, Senior Counsel, assisted by Mr. P.K. Medi, the Learned State Council for State Respondents, has submitted that an affidavit has been prepared and the same has gone for vetting. and after receipt of the same will be filed before this court. He prays for a short accommodation, which is not objected by the counsel appearing for the petitioner. Also, your name?
A Wahid, on behalf of Adhar.
So appearing, appears for the petitioner, full stop. Let the matter be listed. When do you want? After 2 weeks. Let the matter be listed after 2 weeks.
First.
Deep blue.
Your Lordship, I am appearing on behalf of Mr. S. Samaria, Lordship. Sometime ago, he left the court premises due to some health issue, Lordship. So I am appearing for a week time, Lordship.
You are appearing for
Mr. S. Samaria, petitioner
S?
S. Samaria, Lordship. He is the conducting counsel in this matter.
You are the petitioner.
Yes, Lordship.
It's 2018 matter.
Yes, Lordship. Just a 1 week time.
Hmm?
Just 1 week time, Lordship. Just few time ago, he left the court premises, Lord.
Okay, Mr. So and so. We'll give him some time.
Very well, my lord. May I pray that a date be fixed if it is not inconvenient to the court?
Heard Mr. So and so, the learned counsel appearing for S. Samaria, the learned counsel appearing for the petitioner. Also heard Mr. N. Chaudhary
For the respondent number 5, my
for
lord.
for the respondent number 5. You are appearing? You're with him. Oh, okay. MSPR Mohanto for respondent number 1. Mr. So and so submits that due to certain personal difficulties, Mr. Chamaria has to leave the court and therefore prays for some accommodation, which is not objected by the counsel appearing for the respondent. Full stop. Let the matter be listed on
Next, just put it down.
7th of April.
7th of May.
7th of May, sorry.
Your Lordship, interim order is there.
Interim order so passed earlier shall continue till the next date of list.
Highly obliged. Lordship.
7th of May.
Your Lordship. This case is relating to payment of compensation of land acquisition under the Zamindari Act. The land was not acquired by.
They have filed an affidavit, you are not filing any rejoinder, right?
What they have filed, my lord?
Huh?
That is, my lord, only 2 pages affidavit they have filed.
No, I mean,
Admitted.
I'm just asking whether you would like to file
Yes,
any,
my lord,
huh?
no, I halfly have drafted, there is not a paragraph that to be denied or my lord admitted. So I have only 2 pages affidavit.
Hmm. So-
So I started drafting,
Uh,
thereafter nothing to state, that's why I have let it.
no, it's up to you. I mean, like,
Yes,
if you
sir.
do not,
Yes, but they have admitted the fact, that's all.
then it's not a problem.
They have admitted the fact, not disputed any fact.
They have not,
Therefore, my lord,
okay.
yes.
You have admitted all? Huh?
My lord, that.
She's saying you have admitted.
She may say so, but we have not.
The department
admitted.
stated that
In fact, my lord,
the
Lordship,
publication of the.
it is
convention-
evident from
See,
the.
madam, see, like, now he's saying that if they have not admitted.
State government has not filed, deputy commissioner.
Now
has
thing
filed.
is that, like, if you do not file any affidavit,
He cannot argue beyond the.
correct.
My lord affidavit.
That's correct. Now, the
And-
thing, now only thing is that, like, if you do not file any rejoinder, then on record, nothing will be there. Then whatever he is saying in his thing, that has to be
He
taken
must
as,
admit, but here it is admitted, my lord, by the deputy commissioner affidavit.
Hmm.
Whatever affidavit is filed,
Hmm.
there it is admitted.
Hmm.
So I've taken it for drafting, but my lord, nothing was to be stated, that's why. Since they have admitted, my lord.
okay, I mean, like, it's, I'm just asking, I mean,
Yes,
with-
my lord, yes.
because otherwise later on it will be difficult.
Since my lord, pleadings are complete.
Hmm.
Otherwise, it has come for hearing, my lord.
Hmm.
Now,
So many times it not come hearing, And my lord partly heard also, my lord, but could not be, my lord, proceed due to different reason.
Hmm.
And there I have prepared a written argument also.
Hmm.
And with other people. Finish?
Is this an additional affidavit in opposition?
No, my lord, wrongly it is, my lord, I was confused and my lord, it is an affidavit of opposition,
Hmm.
but in drafting they have additional affidavit wrongly mentioned.
Okay.
Only one affidavit is there. No comment or admitted. So, nothing to.
Madam, see, in paragraph 4, it may be relevant to you. That's why I'm pointing out.
Yes, my lord.
Because it says that with regard to statement made in paragraph 4 of the writ petition, the deponent has stated that a draft publication issued by the compensation officer Dhubri and a legal notice was hanged in notice board for any objection of legal heirs from any corner, but no objection regarding legal heir was received, and hence a final compensation statement was prepared in Form C by the compensation officer. So this is one statement that you'll have to take care of.
That is
I
true,
think,
my lord.
I don't know, I have not gone through
That is
all,
true, my lord.
huh?
No objection came, my lord.
Hmm,
It
it's
is
a fact.
my lord.
It's a fact. That is not going against you. Okay, good.
Nobody is other contender, my lord.
Okay, correct, correct.
Only they were minor when their father died.
Huh.
And my lord, when the land was acquired, they were minor.
They were minors. Okay, okay.
Later on, after becoming a little bit older,
Hmm.
then they came to know,
Hmm.
and then they engaged a power of attorney since they were child minor.
Hmm.
So my lord.
So
the
you are
power
not
of
happy
attorney-
with the compensation, right?
No, my
What
lord.
is your grievance?
Events, my lord, no, not a single penny has been paid. Although land is acquired, company award was passed, but my lord, twice they came to High Court, my lord. One, my lord, simple order was passed against that, my lord. They filed a review. Thereafter, again, my lord, they have to come. And my lord, a detailed order was passed. Last petition I moved, my lord. A detailed order was passed, my lord, by Honorable Justice Deka.
So
Thereafter,
your grievance is
I
basically
filed
non-payment, right?
contempt case.
Hmm?
This is the third round of litigation. And my lord, first was my lord order at page 28, my lord. This is simple order, Annex 7.
So one inquiry was directed by the court or what?
Don't understand.
Was there any inquiry directed by the court?
Yes, my lord. In the.
That 6/8/2018
Yes,
inquiry
yes, my
report,
lord. I'm coming to that.
that has been directed by the
Detailed case,
court?
my lord, page 34.
Hmm.
Judgment was given, my lord, this inquiry, my lord, regarding, my lord, whether, how much the payment should be.
Hmm.
Payment, they have to pay the payment.
Because
Government
they
has
have
to pay
taken the
payment.
land. They have taken
But,
the
my
land
lord,
payments.
what will be the amount regarding that, my lord? And inquiry was, my lord,
Directed, then
exactly, my lord, that, my lord, last page 39, my lord.
Page
the
32,
order, Page 39,
39.
after giving all details, my lord, accordingly,
This is the second case.
second case.
Hmm.
This repetition is disposed of with a direction to the state respondents to inquire into the matter.
Now,
at
where,
the
where,
level
where,
of
where,
the-
madam? Where 39?
Page 39.
39
Top of the
where?
paragraph.
Huh?
Page 39. Yes, it was written.
It should be 38.
Correct. There
Thirty-
should be
38.
some mistake.
In the copy that has been served to us, my lord, it is page 38.
38.
That is the concluding page of the
Judgment.
order passed by the honorable court, yes. And there, if lordship
repetition is
says,
different.
my lord, paragraph 7. Paragraph 7
No,
at
no,
page
I have to
38.
I have to read from
Oh,
the,
yes, yes, yes.
accordingly,
Paragraph 7.
from top, my lord, accordingly, this
Okay.
repetition
Hmm,
is
hmm,
disposed
hmm,
of
hmm,
with a
hmm.
direction to the state respondents to inquire into the matter at the level of the principal secretary revenue and register management department government of Assam and examine the extent of compensation.
Hmm.
Not other thing. The petitioners are entitled as per the law and dispose of the compensation case number so and so within a period of 4 months from the date of receipt of the certified copy of the order by the respondent hearing.
Hmm.
Further review of the order passed today, in view of the order passed today, the order that so and so has become infractious and as such the same is set aside after completion of the inquiry and order proceeding, the state respondents will disburse the compensation amount to arrive at and in the proceedings. will
So
be
what
further-
happened after this? What happened after
that,
this?
My lord, they did not pay anything, they did not do anything.
No, no, what
Then
about the
I
inquiry report?
filed contempt.
Hmm?
I filed a contempt.
No,
petition.
where, yeah, you filed a contempt petition then?
Contempt petition.
Ah.
After time is over.
Correct.
Thereafter, my lord, in the reply of the contempt petition, they have enclosed and my lord, inquiry report.
Hmm.
Here, my lord, they have totally, my lord, totally set aside that, my lord, we are not entitled, this, that. And my lord, earlier, my lord, the order set aside here was passed.
And
by
what
the-
happened? The contempt case was disposed of.
No, my lord, they have, after that, I have filed this press petition.
No, the contempt
Because-
case is still there.
Contempt case is
Still pending. Then you should have pressed the contempt petition.
No, my lord, because of.
But now you are challenging the inquiry report.
Challenging.
Now
that.
you are challenging the inquiry
Challenging
report.
that report. Yes, my lord. In the opinion opposition of the contempt, at least one page 40, that will be, my lord, page 39, my lord. I have enclosed the opinion opposition filed by them. There they have enclosed, they have not given any copy to me, nor any communication. Finding of the inquiry report conducted by the.
Now, where is the inquiry report?
Page 43, my lord, then. 44 needs. 44.
Yes,
44, my lord.
It starts at page 44, my lord.
yes.
No, this is the
That's
inquiry
what
report
I
that is put to challenge here in mind.
Hmm.
I have challenged this.
Yes.
Funding of the inquiry conducted by the Principal Secretary Revenue and DM Department as per the Honorable High Court order in Pradip so. The ex-tenure holder has no knowledge about the estate for which he claimed the compensation. The ex-tenure holder had submitted his claim on so, almost 50 years after the acquisition of the estate which was received in the office of the compensation officer so, along with the prescribed form of B flexi wherein he had shown that of the total acquired lands of 62 bighas, 19 kotha 4 acres in the name of the estate column, the TH had written the name as Gauripur acquired estate, implying thereby that the details had no knowledge about the estate for which he is claiming compensation because the Mulla Mohtarampur Zamira Aurangabad estate, which was the name of the estate, was a joint estate and was only a small part of the Gauripur acquired estate. What is important is the fact that the compensation officer also did not object to it and gone ahead with the assessment of compensation with wrong information provided in Form B. Government revenue was assessed wrongly in the prescribed Form B against so and non so. Against para so, total amount was payable in the superior so. All these things had written, my lord, so many things. Convention had applied his mind while accepting. If he is not satisfied with the award, my lord, they should have challenged it before the district judge. That is the legal provision. He cannot just deny and, my lord, set aside the award. No authority has been given to him. Against para so, total amount of cess payable to the superior landlord so for the whole 62 bigha 19 land, which is unbelievable, which comes to 15 paisa per bigha. In compensation, officer had not raised any question about this land revenue and accepted in toto despite the fact 15 paisa per bigha, my lord. The documentary evidence was submitted by the external holder to be proved to this rep. The compensation officer had not applied his mind while accepting this land revenue rate payable to the state government. In the case about it itself, there are some copies of petitions submitted by the ASO South Salmara, which shows that the land revenue rate among 2 rupees 52 and 2.8 the compensation officer simply accepted and deducted rupees 10 from the configured. The following paragraphs, it is shown how the compensation officer in total disregard to the provision of law committed mistakes in each steps and assessed compensation. In the form due for part so it is assumed the annual lands payable by the undertenants to him or so as per direction given in the so. This rate has to be calculated on the basis of 15 years average. While all the tenancies were created between 1957 to 61, the oldest tenancy was only 4 years old and newest are 15 years average condition. As given in the Act for calculation of compensation was not adhered to. Moreover, under section 1 of the State Provision Act of Examination, so compensation is to disregard such settlements which file assigning compensation. It's a very long order, my lord. Details have been given, my lord. Should I go to the legal front, my lord?
You see, I mean, well, the initial order was passed. I mean, when a notice was issued,
Yes.
there's a mention that,
If I go to the judgment. my
no,
lord,
no. The short question for consideration is whether such findings of inquiry of the Principal Secretary, Revenue and Register Management Department kept in the file would amount to an order of the state government within the meaning of Article 66,
exactly.
166, 1
Yes.
of the Constitution India.
Yes.
So that was the question which,
That
I
is the
mean.
question, main question,
hmm,
because they have not communicated to us.
hmm,
They should have communicated to the party.
hmm,
He has not communicated.
Hmm.
Only in the reply they have enforced this order.
hmm.
That is that. So in the eye of law, that cannot be an order. In the eye of law, that
Hmm.
cannot be an order.
Then what happens?
That is a nullity, my lord.
Hmm?
That is a nullity, my lord. In some cases, my lord, doesn't litigant have to case to hasten.
No, this is not,
Sundar Singh
now you have challenged this order,
Yes,
inquiry
my
order.
lord. challenge this order
Ah.
because that is a nullity in the eye of law. It cannot stand. One order passed, my lord, which has not been communicated, kept in the file only. That is not. Secondly, my lord, he has no authority to cancel the award. Only they could have filed appeal before the district judge, who is the competent authority for setting aside or acceptance or, my lord, removing the illegality of the order. Whereas any illegality in the order, illegality in the award. Yes. I'm pressing one judgment, my lord,
No, one second.
regarding the order. Yes, my lord. আৰু এখন আছে নে? সেইখন কি হয়? বিচিত্ৰ সিং মানে doesn't listen. Concern. Lordship disputation.
Mr. Borpusari, this inquiry report,
My lord.
Yeah.
in the bottom part, it says that,
So that's what we should.
Since a completely new situation has emerged,
correct, now it is stated that,
since a completely new.
Honorable
situation-
High Court may be prayed to allow government to take recourse
Yes,
to, whether you have taken any action in that.
to recourse up to section and correct the compensation
Hmm.
assessment.
So after
Yes.
after this finding, whether you have taken any steps in that regard, it was done in 2018.
Yes, my lord, thereafter, my lord, some order has been passed, which is the subject matter of the second rate petition. Which has been filed by the same person.
Some orders have been passed.
Yes, my lord.
There is another writ petition or what?
The orders passed by, this is like a page
Yeah,
35.
out of the
No,
petition.
no, it would be sub-
Which second writ petition, Mr. Borpusari?
Yes, my lord, there is a second rate petition. The
Well,
senior-
why, it's pending somewhere else.
Yes, here, in this
Oh.
honorable court itself, my lord.
Which number?
Not listed today.
Then that matter has to be there.
Second rate petition.
One is allowed by law, that is
Hmm?
separate land, separatory.
Hmm?
There's an order to the, there was good order to. Another repetition, my lord,
That's a separate land.
separate land and award is, order is passed and my lord, he has got the money also.
Okay.
Yes, sir, there was his good.
So, so far as, my lord, this page
Different thing.
47 is concerned, my
Their
lord.
name,
Ah.
taken about, media given.
Page 47 is concerned.
Yes.
Now, Lordship will see, Lordship has, my lord, very correctly observed it, my lord, the Honorable High Court may be prayed to allow government to take recourse to section 19. Now, my lord, perhaps this, since this matter is now sub judice, and this very inquiry has been put to challenge. So therefore, my lord, consequential orders are not being passed.
It's a similar case, my lord.
That is the reason.
For interest.
So therefore, my, in the present writ petition, what has been put to challenge, my lord, is the inquiry.
Inquiry report. I mean,
Plus-
because the inquiry report itself has been challenged, you have not taken any action.
Absolutely. Now, this inquiry report is based on, my lord, disputed question of facts and factual metrics. Number one. Naturally, my lord, inquiry will be on, my lord, issue of facts, my lord. There cannot be any inquiry by a government authority on the point of law. Number one. Number two, my lord, Article 166 and all those provisions of the Constitution will not be attracted in the present case, my lord, for the simple reason, my lord, that this inquiry report has not culminated into passing of any order. Had any order been passed, my lord, then the issue of whether the order is a part of the file, it was not communicated, whether that order, my lord,
Yes, I
has
place
been,
my judgment.
has been, my lord, not
When the
passed in
order-
the name of the governor, those issues will spring up, my lord. Then this honorable court will have the, my lord, occasion to examine that order, my lord, on the issue of constitutionality or otherwise. But here is a case where this inquiry report is put to challenge, my lord. And this inquiry report is purely based on facts. It is a detailed inquiry report. Now, this inquiry report, my lord, Lordship will kindly see in the writ petition, there is no factual diagnosis of the inquiry report on facts. Lordship will kindly see, my lord, the statements and averments made in the writ petition, my lord. There is no factual reversal of the, my lord, statements and findings, my lord, incorporated in the inquiry report. Because the inquiry report is a detailed inquiry report. Lordship will kindly see, my lord, it runs to so many pages, my lord. Each and every finding has been given here. That is one aspect of the matter. Secondly, my lord, most importantly.
So, madam, one thing that's what I was madam, I was going through it. See, whatever the contentions you have made. Correct. See, now they have come to,
Your
they have.
Lordship may kindly read me the writ petition, some few of the paragraphs. Otherwise, why this order is illegal?
No. What I'm asking is that, see, this inquiry report is a fact-finding report, correct?
Yes,
Fact-finding report and a very detailed report.
yes.
And all of your contentions earlier made in the writ petition, that has been nullified. That has been almost nullified
Nullified.
because on the basis of certain
Whether
facts.
they can nullify.
Correct, that's
After
what,
acquiring
no,
the land,
that is
after
why,
acquiring the land.
that is why I'm asking.
Yes.
Now, there are two writ petitions earlier, right? Two orders were passed.
My lord,
Two or
all my
one?
petition, yes, my lord.
Hmm?
Yes.
I let two repeat.
And the two writ petitions. So two writ petitions were heard on the basis of some certain facts, correct?
Yes.
Yes, my
And
lord.
certain orders have been passed. And the last order has been passed by a court, by this court, wherein on those facts, that court found it deemed to pass this order.
Yes, my lord,
Correct.
regarding the
And
compensation
order has
amount,
been passed
limited, my lord.
Yes, on
Clerk,
only
only on the compensation amount.
only on the compensation amount, because at that time the court found that everything is fine, the
Everything is
compensation should be paid.
Yes.
The court must have come to a conclusion that compensation is required to be paid. That's why the direction has been given.
Yes.
Now the inquiry has happened. In
Yes.
the inquiries, lot of new things have been have been brought in.
Yes.
Whether rightly or wrongly, that court cannot,
Yes.
till now. But lot of new things have been brought in. Now, in your writ petition, whether you have addressed those facts or not,
X, my lord, number
Those-
one.
those inquiry
Number
thing.
two, he has no.
because you are
once-
challenging that.
No, my lord,
Yeah.
once the court has admitted, my lord,
Hmm.
that has been wrongly, not rightly acquired, and my lord, it is the fact.
So that is
Then, my
why,
lord, what if it is wrongly done, what action they have taken on the
correct,
papers?
correct. That
What
is
action?
why,
Only on the writing on the paper,
Huh.
have to not communicated to anybody.
correct.
That
So,
cannot be passed on, that cannot
yes,
be an order.
absolutely, you are very correct. Yeah, absolutely, you are very correct.
Yes,
You are
yes.
very correct. So that is why this court was asking what happened to the contempt matter. So in the contempt case, what stand you have
I
taken?
think still it is there, my lord. Contempt.
So contempt case will be very important because see, in your case, you have been directed to pay some compensation,
Contempt is-
and compensation hasn't been paid. They come up with a new fact. So whether that can
was
be
a
done
new
or not.
fact. Then, my lord, if it is true, their inquiry is true, then what action they have taken on their officers? Who is stealing some money or some, my lord, inappropriately, my lord, trying to distribute from the eighth
That is not
state
the least
exchequer?
here. That is
What
not
action
the-
they have taken?
That is not the least
That
here.
is the main thing.
That is not the
Otherwise,
least.
somebody will write something that cannot be affected. And my lord, the court has, after several hearings, my lord, going through the details of the case, has admitted, my lord, these papers are okay. Award was passed, interim order was passed, gazette notification is there. That cannot deny, my lord.
Now, what you
But
know,
what my lord
okay,
sitting
ma'am,
here- sitting here, the-
let us see what are your grounds for challenging
Yes.
this?
Kucha order, yes.
Come to the writ petition.
Yes, my lord. Grounds I have, my lord. Guilty of the I have sentence. From page 7, I started, my lord. Para 6. The
Yes.
petitioner finds that the respondent authority did not release the amount payable as an interim compensation award as well as the final compensation to the petitioner. Finding no award, the petitioner approached this honorable high court by filing a writ petition number so-and-so, and the honorable court on so-and-so passed an order hereby directing the respondent authority to complete the entire exercise inclusive of the payment of the compensation within a period of 6 months from the date of receipt of the certificate copy of the order. That the petitioners further states that after passing of the Honorable High Court order dated so-and-so, the Deputy Commissioner Dhubri filed order dated so-and-so one has written a letter to the Principal Secretary Revenue and Disaster Management Department explaining how the award has been passed after following all the prescribed procedures of law. Above and all in the register of compensation case, it is shown as no return is received. After recording evidence from different sources and evidence adduced by the legal heirs of PTH, the compensation officer has passed the award as mentioned above. Moreover, the tenure holder are poor and illiterate person, therefore, in spite of constant pursuit of the matter, it took long time to dispose of the compensation case and passing of the final award. It has been annexed. Then, my lord, that the petitioner begs to state that the respondent authority, in spite of the Honorable High Court order dated so-and-so and letter on so-and-so written by the Deputy Commissioner Dhubri, have done nothing for payment of the compensation amount. Then the petitioners filed a contempt petition being contempt case number so-and-so, and the Honorable Court on so-and-so issued notices to the respondent contemners. Pending, disposal. But to the utter surprise of the petitioners, the state respondent filed their affidavit in the contempt petition annexing a speaking order issued by the Joint Secretary, Revenue and DM Department and Disaster Management Department, had so and so, dated so and so. Thereby summary rejection the awards, summarily rejecting the award for compensation along with ad interim compensation stating that no records relating to the earlier compensation case in respect of the claim of the ex-tenure holders are available. As provided under 17 of the Assam State Acquisition of Zamindaries Act 1951, the award made by the compensation officer is final, and if for any reason anyone, including the authority, is dissatisfied or aggrieved with the order, an appeal is preferred within 60 days of the date of the order shall lie against any compensation officer passed under Section 4 of Section 16 to the district judge of the district in which the state for a major portion thereof is situated. But the respondent authority has not filed any appeal against the above mentioned award before the district judge Thubri. That your humble petitioner being aggrieved for impugned order dated so and so passed by the Joint Secretary of the Revenue and Disaster Management, thereby rejecting the compensation award to the petitioner approached before the Honorable Court by filing lead petition number WPC number so and so, challenging the impugned order dated so and so, and further praying for a direction to the respondents to release the compensation amount immediately. After hearing the parties, the Honorable Court has disposed of the writ petition on so and so, thereby set aside the impugned order dated so and so, passed by the Joint Secretary to the Revenue and Disaster Management. Earlier, my lord, that was set aside by the earlier writ petition, and further directed the state respondents to inquire into the matter at the level of the Principal Secretary, Revenue and Disaster Management Department, Government of Assam, and examine the extent of compensation the petitioners are entitled as per the law and dispose the compensation case number month within a period of 4 months from the date of receipt of the certified copy. That the petitioner further state that in spite of the order dated so and so passed by the Honorable Court, the respondent authority willfully and deliberately ignored.
No, madam, I mean, there is no ground that like why you have challenged this. I have read, I have
Para
gone through it.
11, para 11,
I've gone through it, whole thing.
para 11, that the petitioner respectfully states.
There are
Section
some
16
state
of the
acquisition
Assam-
remedies, yes. But what is your the main ground of challenge of the inquiry report?
Number
No,
one.
no, you
number
are
one,
aggrieved by which
they
are the,
cannot deny the compensation amount after not setting aside the compensation.
no,
order
correct, no,
before the
no,
district judge.
everything, everything said and done, everything said and done.
Yes.
Since you are challenging this inquiry report,
Yes.
you'll have to make out certain grounds that why you are challenging this inquiry report and where are those grounds?
Here, my lord, 11,
Where?
12.
11, 12, you're probably, you are stating about the point.
section. No, my lord, I am quoting the section where,
Hmm.
my lord, that is not been tenable in law. All
Hmm.
up to, my lord, from 11, paragraph 11 to 17. Section 19 what says, section 17 what says, all these sections are there. That's why, my lord, under this legal provision, the order is a nullity. Inquiry report is a nullity. Different sections. They cannot skip the legal provisions.
Mr. Borpojere, how those earlier orders have been passed?
Yes, Lordship will kindly see what is the first order, because the sum and substance of the inquiry report is that, my lord. All the earlier accesses.
See, it was
were-
part of the Gauripur estate earlier.
No,
They are
this-
claiming, they are
They
claiming.
are claiming factually
Hmm.
everything has been, my lord, held to be upside down, and my lord, if the.
Now, why it was not pointed out to the court at that point of time?
No,
The
because.
court has passed a specific order to pay compensation and release. That means court has come to a conclusion
No,
on
second-
basis of certain facts.
No, second order will speak, my lord, for verification. Therefore, lordship will kindly see, my lord, the first order passed by this honorable court.
Hmm.
For a moment, my lord.
Yes, let
Yes,
us go to the
first order, lordship will find that, my lord, at page 27.
27.
Page 27, my lord.
Hmm.
It is by the same petitioner,
Hmm.
because inquiry report.
And this Pradeep Saha was a party in the other case also. He has received that money.
The client, my lord,
The-
for interest he has filed.
Yes,
Yes, I done the case.
that has that has been received.
Minimum They have received.
Mhm, mhm.
Thereafter, when for interest, they
Hmm.
have filed this, and that is also allowed, and they got
That
the
is
payment.
altogether a different aspect. Now,
Okay.
if lordship comes to page 28, my lord,
Hmm.
the second page of the order, my lord,
Hmm.
lordship will kindly see, my lord, last but second paragraph, my lord.
On
In-
consensus.
No, my lord, on consensus prior to that, my lord, in view of the judgment as stated,
Hmm?
lordship will kindly see, my lord.
In view of the judgment as stated.
Stated.
Yes,
The
which judgment?
Yes, judgment, my lord, in compensation case, so and so. Lordship will.
So let us go from the beginning. On consensus, this matter
Yes.
is taken up for final disposal at this stage. As the subject matter is covered by two decisions of this court.
Available at Annex 3 series, that is order dated
Hmm,
16/12/2011, passed in WPC
Hmm.
so and so,
Hmm.
and order dated so and so, passed in WPC number 11. So there were two writ petitions.
Correct.
Now,
Hmm.
those orders are not part of this writ petition, number
Hmm.
one.
Hmm.
Then what has happened, she moved again, my lord.
The petitioner herein is the constituted attorney of legal heirs of the
Yes, that
ex
also I will
tenure
demonstrate.
holder whose recorded land was determined. Hmm.
Under the compensation case so and so,
Hmm.
because since this was a consensus order,
Hmm.
now since nothing has been done thereafter, according to the petitioner, so therefore this petitioner called Pradeep Saha again moved this honorable court. Kindly see, my lord, the second order at page 10. My lord, page 33.
One second, one
My
second.
lord.
But that compensation case, whatever the order was passed, that was not challenged.
That was not challenged.
Then-
Lordship.
See, let us go one by one. That
Yes,
was not
yes.
challenged.
Yes.
Because that was not challenged, this order was passed.
And this order, Lordship will kindly say, I'm traveling, my lord, with the pages at page 27. Kindly see who is the petitioner. Who is the petitioner?
The petitioner is same person.
Yes, Pradeep Saha.
Hmm.
Pradeep Saha was not the tenure holder, is not the tenure holder, nor the legal heir of the ex-tenure
No,
holder.
but he's the attorney holder.
Attorney.
Hmm.
So there was a lot of foul play, my lord, while assessing the compensation. Many, my lord, the illegality took place. The compensation officer had gone arbitrarily, my lord, exceeded his jurisdiction, calculated compensation.
But whether you have challenged that, but whether those aspects can be raised now.
So therefore, Lordship will kindly see the second order.
Second order, okay,
Yes, at
okay.
page 33.
Page 33.
Yes. Why I am drawing my lord's attention, will kindly see, my lord,
Hmm.
the perversity and the foul play is writ large on the face of this writ petition itself. Here, Lordship will now find Pradeep Saha and another.
Correct.
This is the person, Khoimuddin Sarkar.
Yeah, he's the person, okay.
Yes,
Now,
Khoimuddin Sarkar is also one of the, my lord, attorney.
hmm,
Now, Lordship will kindly see, my lord, this order
Hmm.
at page 38, my lord. Paragraph 7, the direction passed by this honorable court, the finding and direction. Kindly see.
yes.
Further, in view of their order passed today. Now here, my lord, prior to that, my lord.
The order dated 9/1/2013.
Yes, it become infractual
9/1/2013 is the earlier date.
earlier.
No, not the earlier one.
No,
What is 9/1/2013?
Annexure 9, my lord, that lordship will see, my lord, at page 30, 30.
That has been satisfied. Passed by Joint Secretary, Revenue.
So this has been made this thing infructuous.
Yes,
Correct. Now, same
Now-
is set aside.
set aside.
Ah.
Now kindly see, my lord, further in view of the order passed today, the order dated 9/1/2013 has become infractuous,
Hmm.
and as such, the same is set aside.
Correct.
Now, this honorable court goes further and states, my lord,
After completion.
of the inquiry, so the authorities were given a leeway to go for
And
an
all
inquiry.
the
Yes, and order proceeding, the state respondents will disburse the compensation amount so arrived that in proceeding within a period of so only after an inquiry, if it is found that if at all the person concerned is entitled to any compensation, then pay it, my lord. This is the tenor, and this has attained finality. Now, in pursuance of this order, my lord, this, my lord, inquiry.
No, got
report
that
has
I
been-
got, that I
yes,
got, that I
yes.
got, that I got.
This is the sum and substance. Now, how these persons, these attorney holders are committing foul play, I will now demonstrate from the writ petition. How they are committing my lord, foul play. They are playing a fraud with this honorable court. I will demonstrate how. From the materials, my lord, and the statements made in the writ petition itself. So everything was done in a hush-hush manner, my lord, in a most illegal manner. Therefore, my lord, the department has to, my lord, step in and pass this inquiry report, my lord, on a detailed inquiry. Each and every aspect of the matters has been, my lord, discussed, gone into, and findings recorded here, my lord. Kindly see, my lord. The first one, my lord, at page 44, my lord.
Just a minute, just a minute.
Yes,
Just-
I'm so sorry.
Just a minute. But there is one holding here. I mean, see, I mean, page 38,
My lord.
38 in the bottom part,
Yes, my lord.
it says it is pertinent to mention.
My lord.
Have you got it?
Page 38, my lord.
The penultimate page of the order,
My lord. Second judgment of this.
second
honorable
judgment,
court.
yes. And the bottom part
My lord.
towards the eighth line from the bottom, it is pertinent. Have you got it? Towards the right side,
Yes.
it is pertinent. Page
Ye-
38.
Yes, 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 yes.
Huh?
I got it, my lord. Yes, yes.
It is pertinent to mention here that
My lord.
this court has observed that there is no denial of the fact that the present petitioners are not entitled
Yes.
to the compensation within the ambit and scope of the act, inasmuch as there is a gazette notification dated 4/4/1962,
Yes.
wherein the serial number 255, name Somsar Ali so and so,
Yes, my
so
lord.
and so have been shown as the holder of jot number 17 covering so and so, so and so.
Yes, my lord.
So under the Compensation Act, he is not entitled. Is it so?
Yes. my
Under
lord.
the Compensation Act, he is not entitled because it was a estate zamindari land.
Yes, my lord.
The
What-
gazette notification has come.
Yes,
Mm.
my lord. Now, after coming into effect of the Act of 1971, my lordship is aware, my lord, those zamindari estates in erstwhile Goalpara district, my lord, those were acquired
Mm.
in terms of those Act, my lord.
Mm.
And now that acquisition has to be done, my lord, by publication of gazette notification
Mm.
for various part and
Correct.
parcels of land.
Mm.
So the fact that those lands were acquired, my lord, is not
It's
disputed.
not disputed.
We are not disputing it.
Mm. Mm.
We are only disputing, my lord,
Mm.
with regard to the entitlement of the writ petitioner, my lord.
Mm.
Entitlement of the persons concerned in terms of that, my lord, notification, gazette
Whether they are really
Yes,
really the
yes.
owners or not.
Yes, because otherwise statutorily the state government is bound under the act to give compensation.
But whether these persons are entitled or not.
Absolutely. Now, on facts,
Mm.
it has been clearly demonstrated, my lord,
Mm.
in the inquiry report
Mm.
that every kind of foul play has been committed. And lordship, for a moment, lordship will kindly see, my lord,
Mm.
that inquiry report, my lord.
Correct.
I am just troubling, my lord, with.
No,
few
no,
pages,
please,
my
please,
lord.
please. I need to be clear on facts.
I'm so obliged, my lord.
Mm.
Lordship is giving a patient hearing, my
Mm.
lord. I'm so obliged. Lordship will kindly come to, my lord, point number 4, my lord.
Yes.
That page 45. The second page of the inquiry report, my lord.
So no documentary
No
evidence.
documentary evidence. There, lordship will kindly see, my lord,
Mm.
down below, my lord, that paragraph, the present revenue paying receipts.
Mm.
His lordship got it, my lord.
Yes,
That's-
yes.
That's, my lord, what he foresees.
Yes,
right
yes,
from the
yes,
top,
yes.
In that paragraph.
Yes.
The present revenue paying receipts are also issued by the ETS, my lord, that means the ex-tenure holder,
Mm.
but his signatures on the forms are doubtful.
Mm.
So the signatures, everything was doubtful.
Mm.
Now that same foul play is being committed in case of the present writ petition. How? Lordship will now kindly see, my lord. Lordship will kindly see, my lord, paragraph, my lord, 7 of the writ petition. Lordship kindly see, my lord, paragraph 7 of the writ petition. What has triggered, my lord, the authorities to go for the detailed inquiry? Same
Paragraph
thing is
7.
Paragraph 7.
Mm.
Paragraph 7, my lord. The last line, my lord.
Mm.
Moreover, the tenure holder.
Mm.
Lordship got it, my lord.
Mm.
I'm so obliged. Moreover, the tenure holder are poor and illiterate person.
Mm.
Therefore, in spite of constant pursuant in the matter, it took long time to dispose of the compensation case and passing of the final award.
Mm.
Now they say, my lord, that these persons are illiterate persons. So therefore, they are not in a position, my lord, to
Pursue the case.
pursue the case. So therefore, they had engaged them, my lord, constituted attorneys, two attorneys. Now, lordship will kindly see, my lord, the power of attorney. That starts at page 19, my lord. In my soft copy, my lord, it is 19, Annexer 1.
Page 19.
Yes,
Okay.
my lord. Lordship will kindly see.
Mm.
Kindly see.
Mm.
A statement on oath at paragraph 7 in the writ petition is made to the effect that the tenure holders.
No, no, where is that? Where is that?
My lord,
Where are you reading?
my lord, Annexure 1, page 19.
Uh-huh.
That is the general power of attorney.
Correct, correct.
Yes, if I may read it, my lord.
Hmm.
Know all men by this present that I, Abdul Kasam Mullah, son of so-and-so Mullah, legal heir of Abdul Raham Mullah so-and-so. No document whatsoever has been annexed to this writ petition to show and to demonstrate that this person is the legal heir of that, my lord, original tenure holder. Number one. Number two, he appoints, my lord, appoints he Khoimuddin Sarkar. Therefore, lordship has seen, my lord, in the second order passed by this honorable court.
He
in
is
the
a party.
second- He is a party. And in the first writ petition, this Pradeep Saha is the second constituted attorney. By this power of attorney, two persons has been constituted as attorneys.
But now the only thing is that like this Abdul Khanam Mullah is stating that he is making them power of attorney.
Power of attorney, and it is being signed. Lordship, kindly see, kindly come to the last page. In fact, in all the pages, my lord, his signatures appears.
Where
My lord,
page?
if lordship takes the first page, first page,
Where?
first page, my lord, on the right hand side, my lord, on the
Yes,
right hand.
yes, Abdul Khanam, yes.
Yes, lordship will kindly see.
That has been signed in Assamese.
Yes, and now the second page, page 20.
Yes.
Second page, signature appears.
Correct.
Third page also signature appears. So if this power of attorney is the very foundation of this writ petition, if this power of attorney is now, my lord, held to be true, then this statement at paragraph 7 is a false statement. And the petitioner is exposed to the offense of perjury.
So you're only saying that, I mean, you're saying that since the statement has been made as illiterate.
This is one of the instance. I want to correlate this instance with the findings in the enquiry report. Because in the enquiry report, the principal secretary of the revenue department, who is the highest officer, has come to a
No, tell me one thing. This
My-
Abdul Khanam Mullah,
my lord.
late Samser Ali or whatever,
Yes.
Samsul Ali,
Yes,
Samsul Ali Mullah,
yes.
their name appeared in the in the list of the people whose land have been acquired is there or not?
Yes, yes, appear.
Their name appeared. Then how can you question this?
No, but their name appeared because that gazette notification is not a part of the writ petition. What has been annexed to the writ petition is the compensation statement. That lordship will find at page 23, annexure 3. Now, this compensation statement has held to be, my lord, is being, my lord, found to be absolutely illegal, my lord, by the enquiry officer. This compensation statement, my lord, the third column, lordship will find, my lord. The third column, lordship will find name of the compensation holder with father's name and address. The third column, my lord. Form C compensation statement.
Third column is like Abdul Qasim Mullah.
Yes. It
So
will
Abdul
figure-
Qasim Mullah is there.
Yes. Now, who has prepared it, my lord, by the compensation officer? And in the enquiry report, what is the finding? That this Form C statement was being prepared absolutely in an illegal manner.
No, what illegal manner?
Illegal manner, my lord, this is the finding, my lord. Form C, kindly see, my lord. Form C. Form B to Form C, everything. That lordship will.
No, what is the illegality?
So illegality, my lord, illegality, lordship will find, my lord, that no documentary evidence against the claims made, my lord. Number one, my lord, it is the fourth finding. And the first finding is, my lord, the ex-tenure holder has no knowledge about the estate for which he claimed compensation. So who is claiming what is, they are not even sure, my lord. These are all speculative, my lord, litigations, if I may submit, my lord.
Okay, we will hear it some other time. It will not be completed today.
Sir, for two questions, my lord. Illiterate means, my lord, that laborers also signing their register, money receipt register. They can only put the sign.
But
illiterate means, my lord,
thing is that like it is written in a very beautiful handwriting.
Yes.
Beautiful handwriting. It doesn't look like a person who is.
I have to inquire how much classes they have studied. Maybe they are class 8, maybe class 10. But they are not.
See, madam, I mean,
Number one.
first thing is that if you study till class 4th standard
Yes.
with that kind of background, I mean, handwriting depends, of course. And somebody who has studied till 4th also in earlier times, their handwriting used to be very good. But
I have to inquire, my lord, how many classes they have studied. But my lord,
no,
they
that
have not
we may not
declared
require,
any
but he is contending that
personal case.
a beautiful signature has been made. And you have
Excellent.
made a statement that
But
he is
my lord,
illiterate.
letter only I want to place, my lord, that page 30.
Hmm.
It is written by the Deputy Commissioner to the Principal Secretary, Government of Assam. Everybody is false, then I can't help. The government.
Page 30. But this has been set
Annexure
aside.
8,
Oh, no.
Annexure 8. Annexure 8, my lord.
Huh?
Annexure 8.
This is 9-1, no? Or
Annexure
something
8,
else.
9 not 30.
This is
Page 175.
17 May.
Today I'll make
Okay.
it, my lord. Case be like
Mhm.
difference.
That is a
Annexure
communication
8, my
dated,
lord.
my lord, 17th of May 2012.
12, yes.
Here, my lord,
This is
Jamindari
by the
compensation
deputy
case number.
commissioner. Deputy commissioner is the compensation officer. Yes,
Yes.
yes, yes. Sorry.
Sir, with reference to the above, I have the honor to state that the office records against the compensation case number so-and-so, the present case, have been verified thoroughly. It is found that the former compensation officer maintained a case register wherein the above case had been registered, and the former compensation officer passed an order on the register on 24/11/1964, stating that return not received from ex-tenure holder ATH in this case. So. it
So
can be
what does it mean
reasonable-
by return not received?
Let me come to the conclusion, my lord. So it can be reasonably believed that the ex-tenure holder had not received the notice and no return had been submitted.
Okay.
Of 1964 letter, my lord, he is talking about.
Hmm?
19, dated, my lord,
Hmm.
register is 24/11/1964 noting. Based on above, it can be presumed that the former compensation officer did not proceed with case number return was received. However, it is pointed out here that besides the above register, no other record is available relating to the above noted compensation case in the office record. On 24/6/2011, one so-and-so filed a petition along with B form and gazette notification for fixation of compensation. The present compensation officer called for a detailed report on the said claim petition from the circle officer, assistant settlement officer, South Salmara, and on receipt of the report and the registered power of attorney executed by the legal heir of ETH, and the ETH were informed to submit documents, evidence, etc. to substantiate their claim of compensation. Accordingly, they file documents as exhibits and adduce evidence in support of their claims. The compensation officer examined and passed an order for ad interim compensation and final compensation order, which have already been submitted to Government Revenue Reform Department. The legal heir of the external holder in the evidence stated that the external holder and the legal heir did not receive the notice to submit return, and no compensation was received for the said acquired jot. It is also evidence that the legal heir of the deceased ex-tenure holder were minor at that time, and they searched the case for a long time, and after getting the details of the case, they filed claim petition after a long gap for claiming compensation as per deposition before the compensation officer. Deposition before the compensation officer, personally came, my lord. Thus, it appears that no compensation in the above case was made as per proviso of Assam State Jamindari Act 1951, so far available in records indicate. Copies of the case record of compensation case number so-and-so as intimated on so-and-so, along with copy of extract of the compensation register maintained by the compensation officer with his order dated so-and-so in case number so-and-so are enclosed herewith for ready reference. This is for a favor of your kind information necessary action. I don't know how much educated is this principal secretary. Simple English is there, everything details written by the deputy commissioner.
Principal secretary is madam probably an IS officer. Obviously, he is an
Yes,
educated person.
But who has written, his PA has written or somebody has written, I don't know, my lord. But he, that much knowledge he should have communicated the inquiry report. He has not communicated to anybody. Keeping in that file will not make it order. That much knowledge he should have.
So this order was passed
Order no, the letter
Sorry, this letter was
issued on, my lord,
17 May.
17th of 2012.
And this
When-
enquiry order, enquiry was of which?
At that time only, 2012, my lord.
No,
No, it is 2018.
2018, my lord. It is 6/8/2018.
So that person and this person is different.
And my lord, this
But
deputy commissioner is the compensation officer under the 1971 Act.
additional deputy commissioner is the compensation officer. Deputy commissioner do not take all this.
It can be deputy also, it can be ADC also.
ADC,
probably.
ADC also,
ADC,
but-
mostly ADC, sir. Because he talk
But-
about the compensation officer, not himself.
Compensation officer, that is the collector, my. The collector happens to be the DC, my lord. Now, all these prior communications and my lord letters have culminated into the inquiry.
No, what basis, Mr., I have failed to understand what basis Mr. Barkataki has alleging that this person, they have personally appeared before the compensation officer. Now he is telling there is somebody else. On what basis, my lord? What proof he has got to make such a serious allegation?
Now, this enquiry officer, this enquiry was submitted by whom?
Submitted by the principal
compensation
secretary.
Principal secretary.
Principal secretary.
Principal, whether
He has
he's,
not come for anybody, did not call anybody for enquiry or details. He has been authorized by the court to decide the compensation amount. Limited to that, whether he will pay all the entire cases fraud, why they have two petitioners gone, they have never accused that. He has come with a fresh allegation, this everything false. And this order in the first motion itself, it was.
okay, we'll take up some other time,
Yes,
madam.
my lord,
Some other time, because we'll have to go through this.
yes.
The old matter, then another thing is that enquiry report has to be properly gone
And the
through.
report is not exist in the eye of law. He
That
not
has to be seen,
communicated to anybody.
that has to be
And have
seen,
been placed, my lord, the Tajan Little Supreme Court case, my
and
lord.
that has to be seen, I mean, that
Little
has to be seen.
complicated. How it can be, in the motion itself, it was detected by the honorable judge, my lord. In the motion itself, order was passed as Article 136, it cannot be a order in the eye of law. So.
That we'll see.
You should not
Mhm.
discuss about this, my lord. This week your lordship will be there, I think. Can it be fixed on Thursday? As per that, my lord.
We'll fix it on
May.
25th of May. Because this court will not be there. Otherwise, I'll have to release this from part third, because today it cannot be concluded.
So maybe please to
Thursday,
keep this as
Thursday.
a part, lordship
Hmm?
is heard it at
Thursday.
length, my lord.
That's why, I mean,
Heard it at length, my lord.
because I have heard it, that's why I'm
Yes,
keeping
yes.
it. But if you think, because I'll be not there for 2 weeks.
My lord,
From the next
we
week.
respectfully submit my lordship, maybe please to keep this as
Hmm.
part. I think my lord, my senior
lord,
colleague will
lordship
also
is
agree.
That's why I'm giving you that on 25th.
25th of May.
May.
Yes, my
It's a
lord.
Monday, my lord.
Monday is not a problem, it's a part third matter.
Motion,
Part
how
third matter.
many orders nowadays difficulties item did not reach, my lord, in most of the
Part heard matter, my lord.
Father had maybe, but motion orders so many things.
Or we can fix it on 28th.
26.
28.
26 is,
28.
26 is, my lord, Tuesday.
28.
28, Thursday, 28, yes, sir.
Yes, sir.
28th of May.
28 of May.
As part,
28th of May, we'll try to see what can be done.
as part your lordship is speaking.
See, I mean, it's up to you, because this court will not be there for some time. If you think that like, you have urgency, then we can.
No, this is because hearing has been done in so many courts, my lord. But my lord conclusion has.
But no part third matter, but there is no order of part third.
If your lordship keep it as part then you'll come at the top. Otherwise again.
No,
you will go-
no, what I'm saying is that earlier matter was not part third anywhere.
Not part
Heard
not
at
part
length,
but
but,
hard this.
on some occasions, my lord, it was hard,
Hard.
not not
Three-
with this
three
much of
occasion it was
lengthy
hard.
hearing, my lord.
2-3 occasion
Not
it
to
was
the
hard.
extent of lengthy hearing as has been heard by your lordship today.
Okay, then we'll keep it at part third if you
Yes,
do.
Yes, no objection about this.
We'll keep it at part third.
Finishing matter is lucky for us, whatever the result is, because my lord, nowadays my lord, item did not reach
No, only thing is that,
So many
see,
courts
I
are
mean,
there. before all the courts.
it will require some kind of, I
Yes,
mean,
absolutely,
consideration.
Absolutely.
Because his allegations are quite
But
strong.
different person, his means he's different person, but man, they
Now-
was said, they
now-
personally. At that time when the land.
Okay,
was
we'll
retained,
keep it
they
on,
were
we'll
there,
keep it
minor.
on this, 28th,
28th of May.
28th of May.
I'm
Okay,
so
heard MSN Sakia, the learned counsel, appearing for the petitioner. Also heard Mr. R. Barpuzar, the learned standing counsel for revenue department, revenue and register department. Government of Assam. You are appearing? For Mr. J. Hendik for 4 and 5. The matter was taken up for hearing and the same
Gazette notice.
has been substantially heard. Full stop. Let the matter be listed on 28th of May as a part of matter.
Online. I've given some decision, my lord. You will
Yes,
keep it
those will
on
be
file,
done.
yes.
Those will be-
So obliged.
পারবতানি তুমি আগরবার হেৰি গোস্বামী গিলা কনফিউজন কৰি কি হব কি হব বেলেগ ডেট দিলে সেনেকা আকৌ হেৰি আমাৰ দেৱাইছে অৰ্ডাৰ দিলে